Good morning. Welcome to the Santa Barbara County Planning Commission hearing for March 1, 2023. Please join me for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, to the republic which stands one nation under God, indivisible, with liberty and justice for all. Thank you. Mr. Villalobos, how are you today?
Good morning. I'm doing well. How are you?
Great. So would you perform our TV coverage announcement and then follow that with our roll call?
I'd be happy to. Thank you. Planning Commission hearings are televised live on County of Santa Barbara Television, CSB TV, Channel 20 at 9 a.m. in the South Coast, Lompoc, San Ynez Valley, San Maria, and Orchid areas. Rebroadcast of Planning Commission hearings are on Fridays after 5 p.m. on CSB TV Channel 20. Today's hearing will also be streamed live on the county's website and will be available for download in a day or two. Moving on to the roll call, Commissioner Cooney,
Here.
Commissioner Bradley,
Here.
Commissioner Farini,
Here.
Commissioner Martinez,
Here.
and Chair Park.
I am here.
Thank you.
And Mr. Wilson, will you give us your agenda status report? Probably ought to be easy today.
Mr. Chair and Commissioners, we do have a long standard agenda, or agenda. Yeah, I was just trying to play off of what you're saying.
I
We only
know.
have one
I get
item.
it. I get it.
We only have one item. Tough crowd today. We have one item. Staff and the applicants are here, ready to present on that item for the commission. I can move the projection report if you'd like, Mr. Chair.
Please do that.
Our next hearing is next week in Santa Maria, and it's the March 8th, and that is to have a presentation and consider the Solomon Hills General Plan and Rezone Application Acceptance. And again, that will be in the Santa Maria hearing room next Wednesday. Our next hearing following that is on March 29th. That will also be in the Santa Maria hearing room. And that is, there's two items on that project, on that agenda, the North Fork Ranch Frost Ponds project, as well as an appeal of a cannabis cultivation project that's located in the Lompoc area. And then moving down the projection report, we don't have anything projected for April 5th. And then on April 12th, we have one item projected on that, which is the another general plan and rezone application acceptance, and that is in the Santa Maria hearing room. So our next three hearings after this will be in Santa Maria. And then moving down the projection report, we have our next hearing will be April 26th. There's three items projected on that: a lot line adjustment, Isla Vista Recreation Parks Department has an item, and then safety element update by Long Range Planning, and that will be here in the Santa Barbara hearing room. So we won't be back here until April 26th. And then looking at the projection report, we don't have anything else projected until we get to June 14th. And then we have the cannabis storefront project in Los Alamos, which is projected for June 14th, and that's another Santa Maria hearing. That concludes the projection report, Mr. Chair and Commissioners.
Very good. Now's the time for our public comment. Public comment at this stage of the proceeding is for items that are not on our agenda. And our total public comment time we allocate is 15 minutes. We've never gone anywhere close to that. And I would ask you to hold your comments to 3 minutes or less if you're going to make public comment. So do we have anybody that wants to make public comment today on something that is not on the agenda?
Mr. Chair, I don't see any hands. I believe our speakers were for our standard agenda item today.
Okay, next on our agenda is the Planning Commissioner's informational reports. Do any of my fellow commissioners want to make an informational report on what's popping in their district or their life or whatever they want to talk about? What boring people. Okay. Yeah, there you go. Well, our director's report ought to be more exciting then.
Good morning, Mr. Chair, members of the commission. I feel I'm going to disappoint you. I'm sorry. My report is short today.
Oh, well, I'll act excited.
Yeah. So just a quick note that the housing element update. Public comment period closes today, at the end of the day. So once that closes, we will be spending the next 2 weeks, 10 business days, reviewing all the comments, making any changes to the document that are necessary, and then we will be submitting it to the state, at which point they'll take 90 days to review it. And then I have a couple of future board items. We talked about it last week. The long-range work program is going to the board on the 21st of March. We will be briefing the Planning Commission after that on the direction we get from the board. Budget workshops this year are a little bit later than normal. They will start the week of April 17th, and then we will have the final budget in June. And then just a reminder that the safety element, which is coming to you sometime, I think, in April, or Jeff, do you know when the safety element is going to be coming? It's on wildfire. Did you talk about that? Yeah, sorry. And then that'll go to the board on May 2nd. April 26th, it comes to you. And that concludes my report. Oh, thank you, yes. There was a board item yesterday that was brought forward by District 4, and that was realignment of the N-bar, C-bar boundaries to be aligned with the district boundaries. So when the district boundaries changed, the BAR boundaries did not follow that change. And so now, like, Los Alamos used to be in the C-bar area for review, and now it will be in the N-bar area for review. N-bar, yeah, N as in north, central and north. So those are the boundaries that got readjusted. And so they follow the district lines, so that the board members appointing those people to the commissions are then from that district. That's it.
Very good. Well, that's the fastest administrative agenda I think I've ever seen. So I don't know if that portends well or not, but here we go. Will you read our standard agenda, our one item on the standard agenda into the record, Mr. Villalobos?
Yes, thank you, Mr. Chair. Following is a hearing on the request of Todd Trump, Gaviota Coast Conservancy, and Gray Fox LLC, appellants to consider 3 appeals, case numbers 22 APL 24, 25, and 26 of the zoning administrator's August 25th, 2022 approval of the Plains Line 901/903 valve upgrade project, case numbers 21 AMD 9 and 22 CDP 48, and to approve the addendum to the environmental impact report State Clearinghouse number 1983110902, and consider the project exempt from CEQA pursuant to CEQA section guidelines 15301B, 15303D, 15311, and CEQA statute section 15284.
Very good. Do we have any ex parte disclosures, site visits, contacts, and so forth from any of our planning commissioners? Mr. Farini?
Thank you, Chair. Yes, Steve Gregg, a consultant for the applicant. I had a phone conversation with him.
Okay. Commissioner Bridley?
I had a Zoom call with Steve Gregg and Jim Youngson last Friday, followed shortly by 3 members of the Environmental Affairs Board at UCSB, Paige Lund, Anna Eisenberg, and Kat Lane. Both of those conversations were talking about points that they've raised in their communications already on file. And then yesterday I had a discussion with Doug Kearns and Anna Citron, also regarding their appeal.
Very good. And, Commissioner Cooney?
Thank you, Mr. Chair. Mine is very similar to Commissioner Bridley's. I did speak by Zoom with Anna Citron and Doug Kern, Gaviota Conservatory, yesterday. And on the 23rd of February, I met by Zoom with 3 members of the Affairs Board, Environmental Affairs Board, students at UCSB, Kat Lane and Anna Eisenberg were there, as well as Bianca Barron.
And Mr. Martinez.
Well, I was anticipating your question there, but yes, thank you, Mr. Chair. Yes, I had a conversation with Steve Gregg on the 24th of February, and just basically indicating about the what was on the agenda today. And prior to that, I had a conversation with Mr. Gregg on the Friday preceding the 24th, and that was just again confirming what was going to be on the agenda. Thank you.
Very good. For myself, all my action was on Monday as I was trying to return to this state. And let's see, it started with a phone call with Jessica Diaz, representing one of the appellants. That was mainly about how the hearing would go. Then I had a in-person meeting with Mr. Gregg for the applicant. And then I had a Zoom meeting with the Environmental Affairs Board, 3 of the people there. And that's all I can recall for ex parte contacts. All right. Let's discuss how this hearing's going to go today. There's a lot of people that want to speak. That complicates things, and what further complicates things is we have 3 appellants. They have some similar issues, but different clients, and so we have to accommodate that somehow. So this is how I intend to do things. First, we'll start with the staff report, as we always do, and that will be followed by questions from the commissioners. For those of you who aren't familiar with our processes, questions from the commissioners can sometimes take 30 seconds. It can sometimes take 30 minutes. It just depends on what they are. And that will impact when we take a break. My general thinking is we can do our staff report and get our first round of speaking from the appellants done before our break, but we'll see. So following the staff report and questions from the commissioners, appellants will speak first. I've spoken to Ms. Diaz. She told me she spoke with the other attorneys for appellants, or would be speaking with them. Because there are 3 appellants, we're going to go longer than we normally would with appellants' presentations. What I've suggested to them is we would go 40 minutes, okay, split among the 3 appellants as they wish to do. And that time will be further split between their opening remarks and their rebuttal remarks, and it's up to them how they want to use that time. So if they go 39 minutes, then they'll leave 1 minute for rebuttal, but I don't think they will. My understanding is they'll probably go 30 minutes on their opening and allocate it 12 and a half minutes to the first speaker, 5 to the second, and 12 and a half to the third. I may interrupt near the end, not to push you or not to hold you to those time periods other than the ultimate 40, but just to warn you that maybe you're eating up somebody else's time. That's just a courtesy. After the appellants speak, we then have the applicants speak. And because the appellants are getting 40 minutes, it's fair that I give the applicants 40 minutes. I don't know if they want to take 40 minutes, it's up to them. And they can divide that any way they want. And then we'll have public comment. We'll probably mix the Zoom calls and the in-person somewhat. Generally, I'll do the in-person first, but there's so many that would hold up all the Zoom people. So we'll see how that goes. After public comment, we'll return to rebuttal from the appellants and applicant. The applicant basically has the last word. I don't know if that means anything or not, but those of you who are speaking and making presentations, please be aware of that. Then we have questions of staff and any comments from staff they want to make. And then we go to deliberations, and then hopefully we conclude. So that's the general idea today. On public comment, I want you to think about this. I want to take those who are willing to hold their public comment to a minute or less first. So if you're in a hurry, or if you just want to say, I really like oil, or I really don't like oil, or something like that, and it's a simple comment, then line up. And you can line up through Zoom. Mr. Villalobos knows how to do this, or literally against the wall. If you're here, we'll do it some way. And you'll go first. Those that don't take that option, you'll have 3 minutes, okay? 3 minutes apiece. And you'll go after the 1 minute people. That's how it'll work. Okay. Staff, are you ready to roll? Let's do it.
All right. How's this? Okay, great. Good morning, Chair and Commissioners. My name is Katie Knoll, and I will be presenting the Plains Line 901-903 Valve Upgrade Amendment Appeal today. The appeal case numbers include 22 APL 24, 25, and 26. The cases being appealed are 21 AMD 9 and 22 CDP 48. Today, I'm joined by Aaron Briggs, Energy, Minerals, and Compliance Supervisor, and John Zorovich, EMC Manager, is attending on Zoom. I do have a lengthy presentation, so bear with me. The project before you is the request for an amendment and a coastal development permit to install 16 new valves along the existing 901-903 pipeline system running from the Gaviota Coast to the Los Padres National Forest within Santa Barbara County. The project would amend the originally approved Celeron All-American Pipeline Project's major conditional use permit and final development plan as they were revised in 1988. The site plan on the left of the slide shows the pipeline alignment where the pipeline starts in Las Flores Canyon and heads north towards Kern County. The project is necessary to comply with California State Assembly Bill 864, which mandates operators to install the best available technology, or BAT, on existing pipelines within the coastal zone to reduce the volume of fluid released in the event of a potential line failure. The bill requires installation of BAT by April 1st, 2023. The project includes installation of 5 check valves, which use a one-way valve system that automatically closes when pushed back on, and 11 motor-operated valve stations, or MOV stations, which use an external power system supplied by either solar or a below-grade or aerial drop connection to an existing power line. The figure on the left shows the locations of the 5 check valves labeled in pink and the 11 MOV stations labeled in blue. The check valves would be located underground, while the MOV stations would require above-ground equipment within a chain-link fence enclosure, as shown in the bottom photo. Once installed, all disturbed areas would be restored to their prior condition. 9 valves would be within the inland portion of the county and 7 within the coastal zone. The CDP only applies to the 7 valves within the coastal zone. Staff prepared an addendum pursuant to CEQA Section 15164 for the proposed project. Criteria listed in 15164 directing the presentation of an addendum can be met. The addendum to the originally approved EIR-EIS analyzes impact areas listed on the slide. The mitigation measures applied to the original approval are applicable to the proposed project. No subsequent EIR or addendum shall be required. Additionally, the project can be found exempt from environmental review under the CEQA exemptions shown on the slide. The use of both an addendum and exemptions may be unusual. However, this approach has been established through case law and has been reviewed and found to be appropriate for this project. The project would be in conformance with all applicable policies of the Comprehensive Plan, the Land Use Development Code, and Article 2, including the Gaviota Coast Plan. All necessary findings can be made as detailed in the Planning Commission staff report. The valve project application was submitted in December 2021. After processing and approving the application at the zoning administrator hearing in October 2022, Pacific Pipeline Company, or PPC, bought and became the new owner of the 901-903 pipeline system from Plains Pipeline LLP. The owner of the assets is now PPC. However, County Code requires approval of the change of owner-operator application when a facility ownership is transferred. The application for the change of owner-operator has been submitted and is accepted for processing, and the notice for pending action by the director was sent out last week. Therefore, for administrative purposes, Plains remains the applicant for the valve application until the change of owner-operator application has been approved. These applications are independent and do not rely on each other. PPC is present today in the capacity as the owner to answer questions and respond to PC inquiries. However, staff is referring to the applicant as Plains because of this technicality. On August 22nd, 2022, the amendment and the coastal development permit were conditionally approved by the county zoning administrator. Appeals were submitted by the Totram family, the Gaviota Coast Conservancy, and Gray Fox LLC on September 1st, 2022. The next slides identify each issue area and staff's response. Issue Area 1. The supplied visibility analysis is wholly inadequate. The zoning administrator's approval package did not include visual simulations for the proposed MOV stations, making it hard to determine the extent to which the project will affect public views from Highway 101. In response, the applicant provided a full visual impact analysis of 6 of the proposed above-ground MOV stations located near Highway 101 within the Gaviota Coast viewshed corridor. Based on the analysis, the distance of the valve sites, and the speed of cars traveling along Highway 101, staff determines that the visibility of the valves is not considered significant. Overall, the equipment will be unobtrusive and visually subordinate to the natural and agricultural setting within the Gaviota Coast. Issue Area 2. No authority expressly allows a project approval with dual findings for an addendum, statutory, and categorical exemptions. The appellant does not believe that the county may rely on dual findings through an addendum and exemptions. However, CEQA does not prohibit the use of dual findings so long as they are supported by substantial evidence. Here, each valve has been cited specifically to avoid any potential adverse physical impacts to the environment, which support both the use of an addendum and the exemptions. Staff maintains the use of the addendum is appropriate because the project involves only minor technical additions to the originally approved project, none of which will result in any new or more significant environmental effects, and therefore it is acceptable to make the dual findings. Issue Area 3. The project incorrectly relies on outdated baseline in evaluating the impacts of the project. The appellant argues no oil present in the pipeline should be the baseline since it remains idle after the 2015 Refugio oil spill. They also argue AB 864 implementation is required prior to operation of the pipelines, and therefore the purpose of the project is pipeline restart. However, the Office of State Fire Marshal identified lines 901 and 903 as requiring compliance with AB 864 since they are idle and currently considered operational. It's staff's determination that the correct baseline for the proposed project is the existing operational lines. These pipelines underwent thorough CEQA and NEPA environmental review, which addressed the impacts of construction and operation of the lines. In CEQA, where an existing facility has already undergone full environmental review, the original approved project is assumed to exist in the environmental baseline of an addendum or a subsequent project. The addendum should assume the pipeline is installed, existing, and operational, and only analyze the changes to the project, in this case, the valves. Although the restart of the pipeline is not included in the scope of the project, normal operating processes are considered part of the baseline for environmental review. For example, anomaly repairs and pig inspections are common causes for pipeline shutoff and restart. Therefore, an operational pipeline is the correct baseline because the lines have undergone extensive CEQA review, are fully permitted to operate, and have extensive operational history. Issue Area 4. The claimed statutory and categorical exemptions are improper. Specifically, the appellant identifies the 8-mile exemption and claims construction occurs over more than 8 miles in length and spans over more than 1/2 a mile at a time. The appellant states the project actually spans 10.9 miles on line 901 and 61.7 miles on line 903, exceeding the exemption. However, it's staff's determination that the 8-mile exemption is applicable because the area of disturbance for each valve site is between 35 and 82 feet in length, and when taken together cumulatively is less than 0.21 miles. No work will occur in between valve locations. Therefore, it cannot be counted towards the 8-mile restriction. Additionally, to prevent a cumulative impact on a single site, work on 2 or more valves located in the same general vicinity will not occur. The appellant also claims the use of exemptions is improper because the lines are corroded due to the lack of use. However, there's no evidence to support the claim that the lines are more corroded because of their current status. When and if the pipeline is ready to restart, the Office of State Fire Marshal will require a host of integrity-related improvements prior to operation to ensure pipeline safety. Issue Area 5. The project's failure to analyze the potential of reopening of the line constitutes illegal piecemealing because the valve project must be analyzed along with the whole of the action, and it's a reasonably foreseeable consequence that the line will be able to restart once AB 864 requirements are met. Staff disagrees with this claim of piecemealing because the construction and operation of the pipeline has already been reviewed as part of the original EIR/EIS approval. The proposed project scope is limited to the installation of the valves. Consequently, the current addendum's analysis is appropriately focused on the impacts arising from the installation of the safety valves and not on the construction and operation of lines 901 and 903. The subject lines are considered active and remain subject to the regulation of the Office of State Fire Marshal, as well as the Pipeline and Hazardous Materials Safety Administration. Therefore, the only issue before the county is approval of the proposed amendment. Issue Area 6. Cumulative impacts are not addressed, such as those compounded from other related projects within the vicinity. To respond to this, cumulative impacts are not required to be assessed under an addendum. Moreover, staff is unaware of additional valve installation projects being processed within the vicinity besides the existing 3 locations discussed in Issue Area 1 of the staff report. These valves are previously installed and would not lead to a temporal or construction-related cumulative impact. The proposed valves have been intentionally placed to be visually subordinate to the landscape to avoid spatial cumulative impacts. For environmental effects, the valve locations were specifically chosen to avoid sensitive resources. The appellant also states the cumulative analysis should include review of the Refugio oil spill. However, this is not a potential impact of the proposed project and is not appropriate for inclusion in the analysis. Issue Area 7. The project fails to analyze consistency with the general plan, specifically with policies impacted by the addition of oil to the pipeline. For example, air quality policies were not analyzed in terms of oil being reintroduced to the pipeline. Per staff's response in previous issue areas, the scope of the project is not restart of the line. The general plan policies have already been analyzed through the original county approval and were either mitigated for or were covered by the statement of overriding considerations. Therefore, the proposed project's environmental review properly analyzes impacts only associated with installing the valves and not those associated with operation of the line. Issue Area 8. New easements would be required for implementation of the project because the easement agreements for the original pipeline have lapsed, and new or expanded easements are required for implementation of the project. In response, lines 901 and 903 are common carrier pipelines with existing easements with all the landowners along the right-of-way for operation and maintenance. Condition of Approval 18, evidence of right to construct, requires the operator to demonstrate that they have obtained the right to construct the project for all properties involved in construction activities prior to issuance of the zoning clearance. And if the good faith effort to secure rights is unsuccessful, the operator may assert its right as a common carrier pipeline operator to obtain such rights through eminent domain. In summary, staff has reviewed each of the appellant issue areas in detail and believes that they are without merit, and the project should be approved consistent with the zoning administrator's determination. Staff recommends your commission make the following: deny the appeals, case numbers 22 APL 24, 25, and 26, affirming the zoning administrator's decision to approve case numbers 21 AMD 9 and 22 CDP 48. Make the required findings for approval of the project as specified in Attachment A of the staff report, including the CEQA findings. After considering the environmental review documents included as attachment C, the addendum, together with the previously approved EIR, EIS, and the CEQA exemptions, sections 15301B, 15303D, 15311, and 15284, determine that as reflected in the CEQA findings, no subsequent EIR or ND shall be prepared for the project. And finally, grant de novo approval of the project, case numbers 21 AMD 9 and 22 CDP 48, subject to the conditions of approval included as attachment B. That finally concludes my presentation, and I'm available for questions.
Does anybody have questions of Ms. Nall? Commissioner Bridley?
Thank you, Ms. Knoll. By the way, good job on the staff report. I know it's a very complicated case. When you talked about, when you talked about on your slide of issue area 4 regarding the no evidence of corrosion, we had quite a bit of public comment regarding that. So what exactly were you relying on? And maybe I missed it in some addendum, but.
Commissioner Briley, through the chair, yes, specifically for issue area 4, which was brought forward from the appellant, the issue area described in their letter basically stated that because the lines are no longer in use and they've been sitting there, that alone has corroded the line even further than what it originally had corroded from.
Okay.
So it was more specific to the language of the appellant's.
Yeah, okay.
Correct.
And then, when you talk about on the easement matter on issue area 8, is this how staff normally does it? You actually wait for the applicant to secure all the easements for a project at the very end, it's land use clearance. You don't have those be part of the application at completeness review or anything so that we know those are in hand because, obviously there's another big topic in the appeals.
Commissioner Briley, through the chair. Usually for projects, we do require the signature of the landowner before processing an application. This is a unique case in which the county does not require approval of the landowner prior to entitlement of the application.
But you catch that in condition 18. then.
And Commissioner Bradley, in this case, obtaining some of these easements is going to require some very significant effort on the part of the applicant, and it's not really a chicken and egg type of situation. The applicant would need to rely on a project approval in order to forcibly obtain easements that the landowners otherwise don't want to give up. So without that approval, they don't have the ability to gain the easement. But with the approval, they do.
Okay, understand. And last question, sorry to take so much time, but there's been a lot of public comment. Obviously, one of the appeals is on the age of the original EIR from 1985. So I'm just wondering if staff in general, and I apologize, I didn't cover this with staff ahead of time, but how do we do very many addendums for a document that's 33 years old? I mean, how?
Mr. Chair and Commissioner Bradley, to answer your question directly, we don't see this a lot. However, in oil and gas projects, a lot of our facilities were approved back in the 80s and the 90s. And, that was the time that we did environmental review on these projects. So, in this case, we took a good look at the EIR. We asked ourselves if it covered the issue areas presented by the current project, and we determined that an addendum was the appropriate path for environmental review of the current project.
Because I can think just from a practitioner standpoint, I know there are addendums done to general plan EIRs or community plan EIRs, and then something comes in and you cite that with an addendum. And that probably does have a similar time frame, right? Maybe 20 years plus.
Yeah, I mean, the Orchid Community Plan would be a good example of that. It was adopted in the 90s, I believe, and the EIR was certified for the plan at that time. And each of the subsequent key site projects that come forward after that rely upon the analysis in the EIR.
Okay,
This would be similar.
Thank you.
Anybody else have questions? I have some. The staff report states that this is an active pipeline. Who determines that?
Chair Park, that would actually be the Office of State Fire Marshal. They would be in charge of determination of if the line stops operating, if it restarts, things like that.
Now, you use the phrase "would be." I mean, have they determined that? Have they determined that? Do we have evidence of that? They written us something that said this is an active pipeline? Or is that something they could do?
So Commissioner Park, there was a lot of language in the appeal letters that are kind of confusing this issue. And clearly the line at this time is non-operational, right? It is not pumping oil to a destination. It's sitting idle. The Office of the State Fire Marshal in their regulations, a line is either abandoned and no longer in service, or it's active. And even when a line is in idle status like the lines are now, it's considered active for their purposes. It's still subject to their oversight, their regulations. So it feels a little weird to describe the line as being active because it's not operational, but for the regulatory purposes of the Fire Marshal's office, the line is active and therefore subject to AB 864 requirements and therefore the current project.
So in other words, the staff report says it's active because as a matter of law, it's active unless it's abandoned.
Correct. It's an
Okay.
active status.
Right. And to be in an abandoned status, there has to be a declaration of abandonment?
That's
or
correct.
Just doesn't run for a while? No, it needs a declaration.
That's correct.
Gotcha.
And physical changes would need to be made to the pipeline to isolate it and abandon it for it to be officially abandoned.
Okay. Also in the staff report, sometimes I don't follow things that well, but my overall impression from what I read in the staff report is that if this project is approved and Exxon has the right to restart without any discretionary approval, then the restart can go forward without any additional environmental review. Is that correct?
Chair Park, yes, that is correct. This pipeline does have previous entitlements allowing operation of the pipeline.
Right. So whatever people think they're looking at today, one consequence of today's decision will be that there may not be any additional environmental review of the impacts of restart. Correct?
Chair Park, that's correct.
Yeah. This issue of baseline, we've discussed this before. Mr. Briggs will remember that on similar projects. And I read that the determination has been made that the line is operational, the baseline should be considered as though the line is operational. Now, Mr. Pettit, let me ask you this. Is it not the statement in the government code that the baseline for environmental review is generally when the NOP is issued? Is that correct?
Commissioner Park, thank you. Mr. Pettit was covering for a few minutes, so I'll jump back in. So,
Well, I've asked you this 10 times before, so you know the answer.
sure. So baseline, the starting point is when the NOP is issued. However, for projects that have already undergone previous environmental review, especially projects that have already been constructed and operated, the baseline is different.
Well, it can be different if the decision maker makes that determination, correct?
Chair and Commissioners, I'd like to double check that.
Okay.
There are some presumptions when environmental review has already been conducted. The commission does have discretion here, especially with making the 15162 determination and
Right.
whether the addendum's appropriate. But in terms of baseline, I can get back to you in a few minutes.
You might remember we went through this before at our prior Exxon hearing, same application, similar project, exact same questions from me. And I'll tell it like it is. I believe this is not a staff determination. I think it's a determination of the decision makers that if you're not going to use the baseline that's the default baseline of the issuance of NOP, then it's appropriate under the circumstances, when you determine there are circumstances, and it may be here, for the decision maker to decide to use another date for the baseline. But I believe that is a determination to be made not by staff, not by the applicant, but by the Planning Commission, and that should be well understood. But if I'm wrong, somebody look it up and let me know. Okay. Final question, that here the county does not require proof of ownership sufficient to go forward, and that's because of the vagaries of the condemnation process. Is that what you're telling us, Mr. Briggs?
Chair Park, yes, that's correct. Eminent domain specifically.
Right. Which can take years sometimes to sort out and determine compensation levels and public interest and all those things. Okay. Well, those are my questions, and thank you for your answers. Mr. Cooney, I think I've stimulated a question out of you.
You did. Several. I'll just ask one, though. Ms. Null, you're familiar with the original EIR for this project, and there's been some mention of when that was. I thought it was 1983. Is there another date when the EIR was certified?
Commissioner Cooney, through the chair, the draft environmental impact report was prepared in 1983. The final was prepared in 1985. And then the project itself went through another revision later.
Okay, I was looking for that original date, so it's 40 or 38 years ago, right? This is unique in my experience that we rely on an EIR of that age. But the biggest question I have is, what did the EIR say with regard to the mitigation of impacts from oil spills?
Commissioner Cooney, through the chair, the EIR itself identified multiple mitigation measures specifically for biological resources, water resources, soil, things like that. And in terms of mitigation measures associated with the spill, it did rely on, or let me rephrase as its analysis of potential spills, it relied on protection of those specific impact areas identified within the mitigation measures. So for example, there are plenty of mitigation measures associated with sediment and erosion control, limiting the areas to be disturbed within riparian areas, and when discussing potential impacts associated with a spill, it did rely on those mitigation measures to decrease any potential impacts. But then again, there are specific issue areas that were identified to have a significant impact even with mitigation, which is where the statement of overriding considerations comes into play.
So would it be accurate to say that regardless of the mitigation measures being effective, the review of the prior EIR had overriding considerations and they contemplated the possibility of an oil spill?
That is correct.
Okay, thank you.
Any other questions? Well, thank you, Ms. Knoll. You did an excellent job of navigating a very difficult subject matter. Okay, let's go on to the appellant presentation. And Ms. Citron, do I understand you're going to go first? No, I guess not. Mr. Capello.
Morning, members of the commission, Mr. Chairman, staff. All of you probably don't know the fact that I was here in 1969 when the Santa Barbara oil spill occurred and was the city attorney. And I and the deputy county counsel and a deputy attorney general took on Exxon, Union Oil, Mobil Oil, which is now part of Exxon, Gulf and Texaco. there is no more dangerous facilities in the county of Santa Barbara than the oil facilities that we are dealing with. And so it is imperative upon everybody here, especially staff, to remember that the promises made by these operators are promises that in the past have been broken. What is shocking about the application in front of you is it is my office in September that said, why is Plains making this application? They are not the owner of this pipeline. They've sold this pipeline. And how can somebody that doesn't own the pipeline make representations about what they're going to do and what promises they're going to carry out when they are not the owner of the pipeline? Shockingly, I also pointed out to staff that we have been representing all of the property owners along the pipeline who have opposed going forward any further because they have clauses in their easements that say if the pipeline hasn't been operational for 3, 4, or 5 years, it is automatically abandoned, And that lawsuit has been certified for class action in federal court, and we've been litigating it for over 6 years. Think about the following situation. Your neighbor comes in with an application to put a garage on your property. And staff says, well, it's okay because they're going to negotiate an easement later on for that garage on your property. That's what we have here. They not only do not own the pipeline, but the company that is asking for a pipeline, Pacific Pipeline Company, doesn't own the land because it has been automatically abandoned by the terms of the easements themselves. We represent Mark Tatram. We represent the JT Ranch. We represent, it's laid out on our presentation, the Live Oak Bazzi Ranch. We represent the Pine Canyon Road Ranch, that's the Denise and Mike Minot people. Those are just our class representatives, and the Gray Fox and Maz Properties, along with the 150 owners that are class members. Every one of them say, listen, if you are an operator, you may have the right to eminent domain, but you no longer can use that pipeline. That's what the lawsuit's about. An interesting fact that has not been discussed by council, by staff, is this. Eminent domain. Eminent domain exists for a approved public utility. And who is that public utility? It's not Plains. Pacific Pipeline hasn't been approved as a public utility for eminent domain. Pacific Pipeline, by the way, isn't going to be the one that owns this pipeline, because in the actual documents that have been filed with the SEC, Pacific Pipeline, Exxon, has said they're selling it to a company called Sable and a company called Flame. Flame's a SPAC, a special access corporation set up to form a new corporation, Sable, which is going to take title to the pipeline. And by the way, also take title to the platforms, the 3 platforms that are left in the channel. And why do I mention that? Because back when we had the oil spill in Santa Barbara in 1969, 70, 71, 72, there were no environmental impact statements. There was no CEQA. There was no Air Quality Act. Nobody cared about oil spills. And if they did, the government didn't pay any attention to it. So to look at an environmental impact report for Celeron in 1983 and have the temerity to say that's adequate for the citizens of Santa Barbara when we know this pipeline is a Swiss cheese of holes. We know it from the PHMSA report that I attached. PHMSA is the Pipeline Hazardous Safety Administration. They say this thing can't open again. And what did Plains do? Plains said, okay, well, we'll put in a new pipeline. And while it's not mentioned in the staff report, do you know that there is a new pipeline project before the county, going through EIR, review, et cetera, for a brand new pipeline? What is this? Where are these automatic shutoff valves going to be? On which pipeline? The old pipeline or the brand new pipeline? I suspect it's the old pipeline because they don't need to do any more CEQA review, as Chairman Park noted in his pertinent question to staff. There's no, it's over. This is the proverbial camel in the nose in the tent. You let this camel's nose in this tent with this automatic shut-off valve, and there will be no more CEQA. There will be, nobody will look at this again. Because Exxon, Sable, whoever it may be, not Pacific Pipeline, and it's not Plains. Plains is before you, and they not only own the pipeline, but they don't own the land. So I think it's important that everybody understand what's happening here. What's happening here is the following. First of all, we're all in favor of automatic shut-off valves, and so is the county. Do you know that the county sued Celeron in 1990 to enforce them to put in automatic safety valves? And Celeron went to federal court and defeated the county so that they didn't have to put in automatic safety valves? And for 20, 30 years, that pipeline operated without it. And when that pipeline broke, an operator sat in Houston and he went, oh, the alarm's going off. It looks like a false alarm. Ignored it. And 30 minutes, that pipeline poured oil into the Pacific Ocean. And you look at the oil spill, the oil spill that Commissioner Cooney asked in a CEQA report. It's oil spills on land, not in the ocean. Nobody looked at oil spills in the ocean from this pipeline. The owners of the pipeline do not want the old pipeline to be restarted. It can't be restarted. There's a huge amount of work that has to be done on it. By the way, just an interesting sidelight. We have represented not only the owners of the land, but all the fishermen that lost all their income, and they've been paid $186 million now. All the property owners from Hollister Ranch to Palos Verdes, California, that had oil on it from this pipeline, they've been paid $46 million. We represent all the oil workers that lost their jobs because that pipeline closed and wasn't maintained as it should have been maintained. And this staff wants you to adopt this report based on a CEQA report that was done in 1983 or 85, and they cannot even cite it again where it was. And by the way, staff made the statement that it's an operational pipeline, and then the Energy Department said, well, it's non-operational. I have from the Planning Commission, from the planning staff, right here, a report, revised notice of preparation. It was done April 26, 2022, signed by Jacqueline Ibarra, planner, Santa Barbara County planner, and she said the pipeline is non-operational. And she said it 3 or 4 times. It's non-operational. So I don't know what the word active means, and my guess is it's a way somebody is trying to convince you that it's operational. But the county staff said in a report in April 4 times it's non-operational. PHMSA in its report says it's non-operational. It's non-operational because it's a Swiss cheese of 80 anomalies that need to be repaired. It's so non-operational that Plains has put in an application for a brand-new pipeline. And by the way, this pipeline is 24 inches and 30 inches for 903. Do you know what the new pipeline is? 12 inches. So what is the pipeline that we are going to be getting here in Santa Barbara? 12 inches? That's a brand new project, and they need to do CEQA, and they need to start all over again. Is it the old 24-inch pipeline that's full of holes? Is it the 30-inch pipeline that goes from Gaviota to Pentland that's full of holes? That's the question that has to be asked, and that's why when we saw this, we said stop. And I'm the one that raised the fact that Plains didn't have any right to be in here. And I have been raising that for months with your staff. And it wasn't until February 24th of this year that somebody in your staff went, well, maybe we ought to have a change of ownership application. So they whipped out a change of ownership application, which the director approved, noticed the public, which we're going to appeal to the Planning Commission because it was not properly done. And the change of ownership is to Pacific Pipeline. But I will tell you, there is no question that Pacific Pipeline and Exxon and Plains knows that Pacific Pipeline is not going to be the owner. The owner is going to be Sable, and they're supposed to take it over in the first quarter of 2023. Well, we're in the first quarter of 2023. Why isn't Sable in here? And who is Sable? Sable is run by the former chairman of the board of Plains. Thank you. Sable Petroleum, which is going to be taking over the last 3 platforms in the channel, which themselves, I don't know what the condition they are in, and this pipeline needs to get before this body, State Fire Marshal, Public Utilities Commission, and justify that they have the ability to protect the citizens of this county and the landowners that we represent. I worry about that. And why do I worry about that? I worry about that because the history of oil drilling is this. You drill and maintain as cheaply as you can because at some point in time, those facilities are going to end. Freeport-McMoRan closed their 3 platforms off of Point Aguelo. Why? It just didn't make sense to put any more money into those rust buckets out in the channel. Exxon is sitting on a good oil field, but I don't know that Sable's ever going to have the money to take care of those platforms out there. And it's our job now, because when I was in this county, I could smell the oil on the beaches for months, sitting in City Hall. What we had here was, by the way, there's an errata in my report. I said 140,000 gallons. There was 451,000 gallons, 10,000 barrels of oil that hit the ocean, not 140,000. This was minor oil spill, but bad. And they were convicted of a felony. So the people making the application for you are felons who didn't maintain their pipeline, who don't own it, and all of our property owners believe this has been abandoned, and that lawsuit in federal courts going forward. Thank you.
Mr. Capello, I have a question of you, if you don't mind.
Certainly. I'm sorry.
Yes, and just for everyone's knowledge, when I'm asking questions and people are answering, that doesn't get deducted from your time, okay? And I'm asking you, Mr. Capello, because I think of the 3 attorneys who will speak for the appellants, you would be most knowledgeable with regard to the federal court litigation, am I correct?
Yes, that's right.
Okay. You wouldn't know this, but in other projects that have been before us, I'm always a little careful when we're ruling on a planning decision, but it might or might not impact ongoing litigation. I just don't want to interfere with what a judge is
It would not.
doing, you know.
Whatever you do.
Well,
if-
is it going to prejudice either side, what our ruling would be?
Well, if you adopt the staff report that this is an operational pipeline, sure. Plains, Pacific Pipeline, Sable, Flame, whoever we're going to be dealing with in the future will be running into federal court saying, oh, it's still an operational pipeline when we know for the last 7 years it hasn't been operated. And we know it can't be because PHMSA said, we're not going to let you reopen it. It's got to be fixed or you got to put in a new pipeline. And by the way, if you're in Buellton, I'd be really worried because the pipeline goes under subdivision in Buellton. And the new pipeline replacement project called for it to be recirculated outside Buellton. So I don't know which one of the commissioners represents Buellton, but if you're in Buellton, you don't want this pipeline to be under those homes.
That would be me.
Yeah.
But, you know, I know especially if I've got a matter that's in bankruptcy court and it's in front of us at the same time, I'm very wary of doing something. Here, do we have any indication from your federal court judge whether they want this determined first, what we're doing,
No.
or second, or do they care?
No, they don't care. The only impact, I think, to respond directly to your question is somebody, if there was a positive review, we went to the Board of Supervisors where this will go. If it continued there, we're going to go to court. We'll take it to court. I mean, we're not going to sit still on this. We're going to take the director's notice of change of ownership up as well. But the only thing I think would be that they would be saying, well, that we applied for this automatic shut-off valves and the staff report said it was operational when the staff a year ago said it's non-operational. That would be the point that they would argue.
By the way, you mentioned that you were the city attorney in 1969. I wonder if you remember a city council hearing over whether oil companies could continue to use Stearns Wharf from the city council, and there were kind of a bunch of young upstarts in the audience, including me as a high school kid, and the hearing ended, but the city attorney stayed. They were the only ones that stayed in the room. Was that you? Do you remember that?
Well, it was either I or my assistant, Fred Clough. It was one of the two at the time,
Yeah, well,
right?
okay.
And I remember an older guy who was the president of the County Bar Association named Howard Park. Was he related to you in any way?
He was.
Yeah, he was.
Sometimes he didn't want to be, but he was. Well, very good. Okay, well, thank you, Mr. Capello.
All right, any other questions?
By my judgment of time, you took approximately 10 minutes, so that leaves 30 for the rest of you there.
Thank you. And my apologies to the members of the commission. I didn't call any of you. That's not my style. I believe in doing these presentations the old-fashioned way. I have nothing against people calling and talking to you. I think it's very good. But I don't want anybody to take it as a personal affront that I didn't call, and that's because, there was some reason other than that's just not the way I do business. All right? Thank you.
All right, thank you. Ms. Diaz, how long do you plan to take?
5 minutes.
Okay.
And you can hold me to it.
Right. I'm not going to cut you off. I just want to kind of tell you if you're getting
Thank you.
past
I
that.
appreciate it. All right. Good morning. My name is Jessica Diaz. I'm an attorney with Brownstein Hyatt Farber Schreck, and we represent one of the appellants, Gray Fox LLC. We join in the arguments made by the other two appellants, and our appeal was filed on similar grounds, primarily that the environmental review conducted for this project falls short of CEQA's mandates. There are a lot of issues before you today, a lot of CEQA issues and a lot of regulatory issues. So I'm going to use my time to try to amplify 3 points raised in our written submissions that I think should feature particularly prominently in your decision. They can each be formed as a question. The first is, what's the scope of the project that's really before the county today? The second is, do any of the claimed CEQA exemptions apply? And the third is, what's the rush here? So as to the first issue, the scope of the project that should be before you for environmental review, it strains the bounds of common sense that the applicant would undertake the expense and the effort of installing, quote, best available technology on a non-operational pipeline that is never intended to be used. As you'll hear more of in a further presentation, and you can see for yourself in the Sable Offshore Corporation investor presentation that was submitted into the record and attached to Gaviota Coast Conservancy's letter, investors are openly relying on production and necessarily conveyance of petroleum being restarted during Q1 of 2024. There was a bullet point in that investor presentation that advertised the following as a key highlight of the transaction, and I quote, "Asset restart process well underway." So what's the CEQA implication of this for the county as the permitting agency here? Well, CEQA is clear that the project a lead agency has to analyze is, quote, "the whole of the action." A project, in other words, can't be cut up into bite-sized pieces so that no one piece of the puzzle evades CEQA review. This is classic piecemealing, and it's improper under CEQA. Accordingly, the answer is pretty simple here. If the applicant is electing to keep the pipeline in active status, then it needs to proceed accordingly. And the county must analyze not only the environmental impacts from the installation of the valves themselves, but all of the environmental impacts of the reopening of a pipeline that's been non-operational for 7 years. This environmental impact analysis simply has not happened, and the project cannot move forward until it does. The next question is whether any of the claimed CEQA exemptions apply. So there are 4 exemptions that have been claimed. 3 of them are categorical exemptions, and the next appellant presentation is going to explain in detail why none of those categorical exemptions apply. The fourth is the statutory exemption for certain repair, maintenance, reconditioning, and other activities on existing pipelines. And I'm going to tell you now why that does not apply as well. This exemption applies to activities on existing pipelines, but only if certain criteria are met. One of those criteria is that, and I quote again, that the project must be less than 8 miles in length. From valve to valve, this project greatly exceeds that 8-mile limitation on both line 901 and line 903. Staff presented an alternative methodology whereby if you take the actual construction and excavation activities that are being undertaken and sum all of those up, you get a total of about 1/5 of a mile. I will represent to you that we've done all of the research on this statutory exemption. There's a whopping cases of 0 on point, and candidly, the legislative history is not particularly instructive here. But we do have the plain language of the statute. And if you look at the criteria that the legislature imposed on the use of the exemption, you can see that when the legislature wanted to refer to, quote, actual construction and excavation activities undertaken, they were capable of doing so. And they said that those actual construction excavation activities could not exceed a half mile at any one time. When they articulated the 8-mile limitation, they simply said the project must be less than 8 miles in length. Accordingly, this statutory exemption cannot apply, and it cannot be used as a pathway to CEQA compliance. Finally, I just want to say there's no rush here. I think there's been an implication that somehow the county's hand is forced by the safety regulations under AB 864, that there's some sort of time pressure to approve land use entitlements that Plains has requested. To be abundantly clear, there is not. AB 864 and all of the regulations promulgated thereunder are meant to be protective of public health and safety and environmentally sensitive resources. It imposed certain requirements on pipeline operators, and it gave the Office of the State Fire Marshal various tools to enforce those requirements. There's nothing in the regulatory scheme that in any way would force the county to grant a discretionary approval that ultimately enables a pipeline to be opened by date certain. For these reasons, I urge the Planning Commission to grant the appeals and deny the requested project approvals before you. Thank you.
Thank you, Ms. Diaz. I don't see any lights. We may ask you other questions later. Okay, Ms. Citron. By my count, appellants have 24 minutes left,
Okay, all right.
including rebuttal.
And
But I know you won't take 24 minutes.
And David, I have a PowerPoint, would you please?
Well, maybe you will.
No, we will reserve time for rebuttal. Thank you. All right. Good morning, Chair Park and Commissioners. Anna Citron with the Law Office of Mark Chatillo, representing Appellant GCC. First, I want to say thank you to everyone who took time out of their busy days to be here in person and also to write emails and submit those to you in advance. We have a broad base of support amongst the environmental community, and we're very appreciative. I'm going to scoot quickly past some of these slides to really zero in on the key issues. So you just heard from Ms. Diaz that the project is not statutorily exempt from CEQA. The project is also not categorically exempt from CEQA. And I think what's interesting about the approach that's been taken here with dual findings, that the project is both exempt and subject to both exempt and not subject to CEQA, and then separately subject to CEQA, which really doesn't make sense and has no legal precedent. But what it really reflects is a lack of confidence, I think, in any one of these exemptions. As we've seen, the statutory exemption doesn't apply. And the categorical exemption, there are three. The first, for minor alterations to existing facilities, this development is well outside the scope of that exemption, which only allows for minor alterations and is really intended for changes in operation and not physical changes. Here we have extensive excavation, structural development, and as you can see in the authoritative case law from this appellate district, this is beyond the scope of the exemption, and it does not apply. Furthermore, the other two exemptions for small structures and accessory structures are qualified by where they are located. And specifically, where they may impact an environmental resource of critical or hazardous concern were designated, precisely mapped, and officially adopted. Those cannot be used. And what we see here, two of the valve stations are within 1 unit of critical habitat designated for the threatened California red-legged frog, and 1 additional valve within the Gaviota State Park area is within a 2nd unit of critical habitat. And impacts to upland dispersal of these threatened species was not addressed in the biological assessment or any of the documents. Furthermore, this MOV station is very close to designated critical habitat for the endangered Gaviota tar plant, and the pipeline runs through that designated habitat. And then finally, we have the designated critical viewshed corridor, which protects views throughout the Gaviota Coast, the eastern Gaviota Coast area. Because of those sensitive resources and potential impacts to them, the second two categorical exemptions may not be used. No categorical exemption may be used for a project which may result in damage to scenic resources from a state-designated scenic highway. And here, Highway 101 from the western boundary of Goleta north to the Gaviota Pass is a designated state scenic highway. And as the supervisors wrote in their letter of intent, this stretch of highway through the Gaviota Coast is the last best example of rural coastal Southern California and is the largest remaining rural coastline within the southern region. So this is no small thing. The applicant's visual simulations downplay the visibility of these, but when you look at actual photos of similar infrastructure, you can see that it's not, it interrupts the viewshed. It is not harmonious with the agricultural and rural setting and would cause impacts. Finally, categorical exemptions, all of them, cannot be used where there is a reasonable possibility that the activity may have a significant effect on the environment due to unusual circumstances. And here, we are talking about adding valves to a pipeline that has failed in 2015 and has significant corrosion and ineffective corrosion protection moving forward, and I'll talk about that in a moment. As Ms. Diaz explained, investors are relying on anticipated restart by first quarter of 2024 using the existing pipeline. And as you can see here, it doesn't specifically say this appeal, but I'm guessing it is. They're awaiting appeal process resolution before requesting final OSFM approval to restart. So I think really the heart of this issue is the subsequent environmental review provisions and whether the addendum is adequate for your purposes. And what hasn't been discussed, and I think it was touched on in the baseline conversation, but it is important, I think, to differentiate a little bit because we are in the subsequent, because there is a prior EIR. It is not only whether changes to the project result in new significant impacts. It is whether there are changed circumstances in which the project is carried out or new information of substantial importance that show that the project will have more significant impacts than the project analyzed in the 1985 EIR. And a very key distinction, and Commissioner Park's questions about mitigation, I think, allude to this. The pipeline that was evaluated in the 1985 EIR was described as having a fully functioning liner system and effective cathodic protection to protect against external corrosion. Since the Refugio oil spill, we have learned that the liner system is ineffective, that moisture has infiltrated that liner and is causing external corrosion. And moreover, the cathodic protection system cannot function in this environment. So operation of this pipeline will actually require a waiver from the Office of the State Fire Marshal, a waiver for the limited effectiveness of cathodic protection. So what you're looking at here is attaching new valves to a 30-plus-year-old pipeline, which incidentally was the anticipated life of the pipeline as described in the 1985 EIR, without protection from external corrosion. And that in and of itself substantially increases the risk of a crude oil spill within environmentally and culturally sensitive areas. So it is this changed circumstance and new information that must inform your decision as to whether to rely on this addendum, which only looks at the valve installation, and this 1985 EIR, which did not contemplate the current status of the pipeline and the ineffectiveness of their proposed mitigation. Finally, there is a separate basis on which you could base a denial of this project, and that is inconsistency with the Gaviota Coast Plan. We have a host of visual protection policies which also prohibit, and this is actually the comprehensive plan, prohibit skyline intrusion. As seen from public viewing places, the skyline intrusion is not all that obvious, but it is happening on a ridgeline between El Cap and Refugio State beaches, and that's prohibited. And then moreover, we have policies protecting ESHA. And as I said previously, the California red-legged frog habitat, in which 3 of these valve units will be constructed, has not been adequately safeguarded, particularly as to upland dispersal habitat. And moreover, this pipeline crosses 8 coastal watersheds and canyons that are environmentally sensitive. And this further underscores the importance of conducting environmental review. Just to conclude here, and then I'll pass it off to Doug Kern to wrap up for all of us. The project is not exempt from CEQA, and there are there's new information, changed circumstances that render your reliance on the addendum inadequate, and subsequent environmental review taking into consideration the existing state of the pipeline is required. And finally, policy inconsistencies preclude your approval findings. So, Doug, I'm going to come up.
Ms. Citron, I believe that Commissioner Bridley has a question for you.
Sorry, of course. Yes,
Thank
questions.
you. Very technical, and I tried to read everything I could, but you made a point about if the line became operational again, it would require a new state fire marshal approval of what?
A waiver. So ordinarily, cathodic protection must be in place for pipelines like this. But it cannot be because the pipeline is so corroded. So they have to get a waiver. And instead of having an effective cathodic protection system, my understanding is they would do things like increased monitoring. And of course, monitoring did not work so well prior to the Refugio oil spill.
And will you tell us what cathodic protection is? It sounds like something I get at Mass on Sundays, but I know it's not.
I thought it was a doctor's procedure.
It has to do with an electrical charge maintaining the integrity of the metal. I am not an expert in that area, but maybe someone else here can
Good
explain
answer.
more fully. Any other questions?
No.
Thank you.
Mr. Kern.
Good morning, Chair Park, commissioners, staff. Thanks for the opportunity to comment. I really appreciate the extensive comments of my colleagues. Thought I'd just share a bit of personal, as my role as executive director of the Gaviota Coast Conservancy, I'm a newbie to the community, a scant 4 years here, but I'm well familiar with the 1969 oil spill. And many of the community have reached out to me passionately describing the events of that day. We have a board member that on the Gaviota Coast Conservancy where the oil spill in 2015 took place. I might just say that as a young geophysicist, I worked for Exxon, and we were held to a very high standard. I don't normally admit that actually in public that I worked for Exxon. And we had to be very much above high scrutiny. We had to really do a good job. So this makes no sense. This project really makes no sense. You would not in your own home do this kind of work where you would install new parts without redoing things that were known to be defective. So I bring to you the passion of the community calling me saying, what is happening here? Why is this going on? This can't go forward. Please do everything you can. And a lot of environmental representatives have collaborated on the letter that we put together for you. And there are more calling me past the deadline, trying to be involved in this. So there's significant community interest in this, and we request that you uphold our appeal on the project and deny the project from moving forward. Thanks very much.
Okay, so that's the end of the appellant's opening presentation. Appellants, you'll have 12 minutes for rebuttal by my count. The next thing we'll do is the applicant's presentation, but we're going to take a 10-minute break first. So please be ready to roll at whatever it is, 10:37. Good morning again. We're going to resume our morning session of the March 1 Planning Commission hearing. And we're at the stage now, we get applicant's presentation. That's you, Mr. Grieg? There you go. I'm not going to hold you to it because I'm going to give you 40 minutes, but what are you looking to do for the opening part? And then I'll just tell you if you're kind of there. And
I
so you know.
appreciate that. Yeah, we intend to, and we appreciate your direction on kind of 40 minutes for both our opening presentation and our rebuttal.
Yeah.
We hope that we intend to hold 15 minutes for rebuttal, so hopefully we'll be done here in 25 minutes. That was a lot, so we'll address a number of the issues, but thank you.
Sure, that makes sense.
Yeah.
Well, why don't you go to it then?
Great, thank you very much. Good morning, Mr. Chairman, members of the commission. I'm Steve Gregg, representing Pacific Pipeline Company, the ExxonMobil affiliate that owns the pipeline. With me today are Brian Carlin, he's a manager here on behalf of Pacific Pipeline Company, Andrew Craig, project manager on behalf of Pacific Pipeline Company, James Thompson, he's our permitting consultant with SCS Engineers, worked on the application and the technical information, and then Christian Marsh, permitting and CEQA counsel for the Pacific Pipeline Company. I want to begin by thanking staff for their effort in this process. As they stated, the appeals before you this morning are of the zoning administrator's August 22nd, 2022 approval of the installation of 16 safety valves on the Lost Forest Pipeline System, or lines 901 and 903. We're here to reiterate our position that the zoning administrator's decision should be upheld and why the appeal should be denied. We'll be happy to answer questions that you may have at the end of our presentation. There'll be 4 of us presenting. I'd like to now invite Brian to provide some additional detail on on what has been provided by the staff and then also brought up by the appellants this morning.
Thanks.
Thanks, Steve.
Mr. Chairman, members of the commission, good morning. Again, my name is Brian Carlin. I am here representing Pacific Pipeline Company. I would first like to thank the staff for their time and efforts in guiding us through this process, but also developing a very comprehensive and accurate report. So I really appreciate that. In October of last year, Pacific Pipeline Company purchased these lines, which remain active. As the owners, we comply and will comply with all laws, rules, and regulations. Today, the issue before the body is the installation of safety valves to comply with AB 864 and its requirements. During this process, we've recognized that there has been questions raised about restart, but they're outside the scope of this proceeding. Pacific Pipeline's approach is to maintain the same restart and replacement options that have been presented in the past and have been enshrined in the consent decree. But let me be very clear about that. Restart or replacement will not and cannot happen until Pacific Pipeline fulfills those separate requirements through the consent decree. This includes a comprehensive review with the State Fire Marshal as well as their approval and other applicable agencies. Because it's been questioned also, let me discuss the status of the line. Despite allegations raised by the appellants concerning the maintenance and condition of the lines, they have been and are currently maintaining pressure and are actively monitored. Since 2015, ongoing activities have been conducted on these lines. That includes periodic inspections, that includes one-call responses, and routine maintenance. In addition, multiple federal and state agencies regularly audit these lines. Finally, emergency response exercises required by law have been conducted under the purview and the attendance of OSFM, OSPR, PHMSA, EPA, and Santa Barbara County. Most recently, we had an exercise last month that Pacific Pipeline held. So returning to the scope of this hearing, denying the appeals for installation is a vote for compliance for AB 864. That by no means authorizes the restart of these pipelines, and the staff report acknowledges that. At this time, I'd like to introduce my colleague, who will discuss AB 864 in more detail. Thank you.
Thanks, Brian. Chair Park, members of the commission, my name is Andrew Craig. I'm a project manager for Pacific Pipeline Company. So The the Pipeline Safety Division of OSFM is responsible for implementing these regulations stemming from AB 864 as it was adopted back in 2020. OSFM has already approved an implementation plan for best available technology for this pipeline, and that plan includes the valves at issue today. San Luis Obispo and Kern counties have also approved the installation of these valves. As the staff report covers under their comprehensive plan consistency in section 6.3, careful attention has been made to every detail and aspect of the placement of these valves. In locating the valves, analysis was conducted to determine the optimal placement of a combination of both below-ground check valves and below-ground block valves. This analysis considers many factors, including the elevation profile of the line, the spacing between the valves, and the type of valve. The analysis also requires these valves to be automatic and be able to be closed without human reliance. This is all in a pursuit of a robust, best available contingency plan to meet the stringent requirements set forth in AB 864. Viewshed impact to the pipeline's corridor has also been very carefully considered, specifically locating valves intentionally as to not obstruct views of scenic coastal areas, intrude on the skyline, alter natural landforms, and otherwise damage scenic resources. This is well outlined in staff's report. The design of each valve setting minimizes above-ground appurtenances and ensures compatibility with the character of the surrounding environment and existing agrarian developments. The safety valves are also carefully located to ensure that they are outside of potential environmental impact areas. This includes very well mapped and understood cultural areas and biological resources in the vicinity, and consultation was held with the county to review valve siting to assure sensitive resources are not affected. As AB 864 intends, these 16 valves are an added safety measure. They're very thoughtfully designed and located, and they're entirely beneficial to the environment. Thank you for your time today. Christian Marsh will speak next on the merits of the issues brought forward today.
Thank you, Andrew, and thank you, Chair and Commissioners. Good morning. My name is Christian Marsh. I'm permitting counsel for PPC. I have over 25 years of experience in permitting and environmental review, both under the Endangered Species Act, CEQA, NEPA, as well as related litigation. I wanted to commend staff, first of all, for their thorough and well-reasoned report, and believe that the record and the zoning administrator's findings address the majority of the issues raised today. I have been asked to address some of the issues that have been highlighted both in the presentation today as well as some of the comments that have been received over the weekend. I'll start with just the owner-operator issue. I represent a lot of clients and actually a lot of counties and cities where you have private applicants coming before you. And it is not uncommon for projects to transfer in the midst of that permitting process and entitlement process. And that is one of the things that has occurred here with the PPC purchase in October. But make no mistake, PPC has purchased and assumed the responsibilities for that pipeline as of October. They submitted permit application revisions or updates in November of 2022, which the staff accepted. The county has determined that it is appropriate to appear today and to proceed as the project proponent. And ultimately, the end user is not relevant to the merits of this appeal, or at least the issues that have been raised on appeal. I also would just take a moment to talk about the easements, because I know that's on everybody's minds. First of all, the easements, there are existing easements and rights-of-way that are as of record. Those have not been determined to be invalid, and the class action lawsuit is actually not going to determine all the real estate issues that are involved here. So it is totally irrelevant and kind of a red herring. The fact is, the zoning administrator added a condition that requires that we come back and ensure that we have all of the real estate secured prior to the zoning clearances, which are the next approval for these valves, which will come back before the county. And as you can imagine, it would make little sense for the parties to be litigating or negotiating new valve sites when they don't even know if those are the sites and which valves will be placed. So I did want to make those 2 points. To address some of the other issues, for example, on the use of a prior EIR, there's been some concern raised, obviously, about the age of the document, but I would note that the appellants have raised no legal authority that would suggest it's too old. And courts have readily upheld documents that, EIRs that have been more than 2 decades old. And in fact, as was alluded to earlier, Santa Barbara County itself has litigated this issue, and last year received a favorable appellate court decision related to the Orcutt Gateway Commercial Project site, where you used a 23-year-old EIR for support of that project. County Counsel to the Court of Appeal in the Second Appellate District had argued that the age of the document is irrelevant, and the Second Appellate District agreed. On the baseline or environmental setting, I understand the chair's concern about or questions about the prior trucking EIR and even the replacement EIR that's being undergone now. But the baseline is not the current the baseline is not the non-operational aspect of the line under settled CEQA case law. Under the normal baseline, it is, as you would say, at the time of commencement of environmental review or at the time of the NOP. Where you have an existing facility that did not go through prior environmental review, the baseline also includes the historical operations of that activity or that project, even if there are periods of vacancy or inactivity. And there are several cases that have spoken to that issue, and even if they didn't go through prior environmental review. That is very different from the circumstance here, and this is what distinguishes this case from the trucking proposal and from the replacement project, and that is this is an existing facility that has already gone through thorough environmental review, and it's been an actual operation. Thus, the baseline assumes, and this is really a legal determination, not one on substantial evidence, that the original project was fully built out and operating. And this is one example was the Committee for Progressive Gilroy versus State Water Resources Control Board as a waste treatment facility. It had been shut down by the regulators because they had been discharging unlawfully, and when they went to return it to service, they included and used the baseline from that original operations. The appellants have also continued to claim that the alternative or dual findings of an exemption and an addendum are improper. But actually, in that same case, the Progressive Gilroy case, they specifically addressed and relied on both an addendum and an exemption in that case. So there is legal precedent. And in fact, Santa Barbara County itself, you have a lot of litigation, and so you have it gives us a lot of history on some of these issues. But this county relied on both a negative declaration and an exemption in the Santa Barbara County flower and nursery growers case. It's from 2004, but it shows that there is a history of using dual findings or relying on both an exemption and an addendum. There were also some statements in the public comments that didn't come up today in the oral remarks that you can't use both statutory and categorical exemptions. But that is also incorrect, and it's well settled in the case law that a lead agency can stack exemptions, and this means when you're using categorical and statutory exemptions, and you can even use them on individual components of the project. And one of the things we haven't really talked about is these 16 valve sites are independent. They do have independent utility. Each of them can proceed on their own. They have a value in proceeding on their own. We believe that if they're denied, that you would have to make specific denial findings for each individual valve site. And some of the valve sites have no surface facilities. For example, the check valves, there are no surface facilities and very little impact, if none. In any event, you can utilize and stack exemptions, and that was very clear from the case law. On the exemptions, I want to note some language from the Office of State Fire Marshal when they enacted the when they promulgated the regulations for ABA 864. And this is a quote from the regulatory history. It says, because pipelines are existing projects, retrofits are unlikely to need or are exempt from CEQA review. Those CEQA exemptions, including the 8-mile exemption, by the way, specifically address inspection, maintenance, repair, or replacement of a valve, among others. So when OSFM was promulgating the regulations, when the AB 864 was going through the legislature, the assumption was that these could be carried out by exemptions. And that makes sense given the very tight deadline for requiring installation. On the 8-mile exemption, the statutory exemption, the appellants say, oh, well, the valve installation work has to be, it has to be less than, the project has to be less than 8 miles. And that this project is more than 8 miles because that's the length of the pipeline. The plain language of the statute actually talks about the project being the activity that is subject to the exemption. In this case, it's the installation of the individual valve. That activity, as staff duly noted, is even cumulatively 0.2 miles. And so it falls squarely within the 8-mile statutory exemption. And again, OSFM and its regulatory history specifically identified that. Similarly, I would just note that although appellants raised some question about the existing facilities exemption and just saying that physical attachments or physical developments aren't part of the exemption, that's actually false. A minor alteration to an existing facility can include equipment, can include physical equipment. And this is one of the most often litigated exemptions, and the universe is replete with examples of equipment being added to facilities and that falling within the existing facilities exemption. They talk about small structures. Well, and at least in the written material, say, oh, well, this must be too big to be a small structure, or this may be too many valves in order to fall under that exemption. But we have examples like the San Francisco Beautiful case from 2014 involved installation of over 700 telecommunications cabinets within a city and even near historic districts. You have the Simons versus City of Los Angeles case, which involved an 1,800 square foot firearms training building, which was exempt under the small structures exemption. And the reason why that size is important, because the small structure exemption is often used for a single family home. And what the courts do is they say, well, if you're smaller than a single family home, then you fit within the exemption. These valve sites are demonstrably smaller. And in fact, the footprint, even on the motorized valves at the surface, is going to be about 200 square feet. Appellants raised the issue of the location exception. And that is an exception that only applies where it only applies to the Class 3 and Class 11 exemptions. It doesn't apply to the existing facilities exemption. It doesn't apply to the addendum, and it doesn't apply to the statutory exemption, the 8-mile exemption. Under that exception to the exemptions, and I know I'm being a little bit wonkish here as a CEQA lawyer, please pardon me, but it's where a resource of critical concern has been designated and precisely mapped. They reference, well, some of the written materials reference marine sanctuary, and then the slides earlier today referenced the Gaviota tar plant. I would just note that they clearly showed that the valve sites are not within those areas. They're outside of the areas mapped, and as a consequence, that does not preclude the exemption. They also talk about the critical view shed. That would mean that absolutely every project, any project you would ever propose within the Gaviota Coast area would never qualify for an exemption if you applied it so broadly. And that's not what the courts say. The courts say you look at the analysis to see is the project impacting the areas of concern that are mapped in that plan. And in this case, for the view shed, and I'll get to that in just a moment, and I'm hoping, Katie, do you have our report? That'd be great. But we'll address that in a minute. But before I do, they talked about the mapping of critical habitat, and this is a little bit of a misnomer, and really getting into the weeds on Endangered Species Act law, but critical habitat has been broadly mapped, and U.S. Fish and Wildlife Service for years has been basically drawing kind of a general map around a large area. And then in their critical habitat designation, they say that only those areas that have the primary constituent elements, the PCEs, are considered critical habitat within those broader mapped areas. I will look at some of those maps, and I've seen buildings, roads, things that are clearly built out and not habitat for the red-legged frog. Here, the three valve sites are nowhere near, well, two of the valve sites are almost 3 miles from the nearest aquatic area for red-legged frog. The frog will not be there. It is not essential habitat. It does not include the primary constituent elements. One area is closer, but there again, it doesn't have the primary constituent elements. It's missing the cover you need. It doesn't have shelter. It doesn't have other elements of red-legged frog critical habitat. And as the biological resources assessment accurately pointed out, red-legged frog do not occupy the site and are not expected to be there. There's no impact on red-legged frog or critical habitat. They talk about the scenic highway exemption, or exception rather, that says that you can't use a categorical exemption if the project would damage or remove, or I'm sorry, if it would impact a scenic highway or critical resources. But I want to just be very specific. The statute itself, or the regulation itself, identifies what those critical resources are. Will it damage or remove trees, historic buildings, rock outcroppings, or similar scenic resources? None of the valves do that. Almost all of them are completely covered by topography, covered by natural vegetation. And here, why don't I just pause here for a second and talk about the scenic issues, because this comes up both in the exemptions and also in the Gaviota Coast Plan. Appellants have pointed to this sign and they say, oh, see, it's going to be on the ridge line, and therefore it's violating the Gaviota Coast Plan, and then it's going to cause an impact to coastal resources. First of all, the dot that you see in that picture is not the valve. That is only used to try to point you to where that valve is. You actually can't see the valve. It's in there. They painted it in there, but you can't see it because it's so obstructed and so small. And this is 1,800 feet. If you could maybe shift to the next page. Or, I'm sorry, Katie, do you have? Oh, yeah, that's great. Oh, sorry. So motorized valve 1-210P is the one pointed out as being of greatest concern to appellants. and they suggested, that it's going to be on the ridge line, and therefore it will be damaging views. The new valve is set to be installed right next to that water tank. That water tank is approximately 20 or 30 feet, 25 feet in diameter, and about 10 feet tall, which is a greater mass than you'll see from the valve site. As you can see, it's not on the ridge line, it's off the ridge line, and we actually drove out there yesterday, and we tried to find that water tank. We were going 15 miles an hour on the frontage road, which is elevated. We could not find that tank, even though we knew what we were looking for. The point of the report is, traveling at 65 or 75 miles an hour down Highway 101, you're never going to see that. It's screened appropriately under the coast plan by vegetation and other topography. Let me also talk about the unusual circumstances exemption briefly. There was a statement that, well, because of the unusual circumstance, in this case, Katie, I'm okay. That's good. Thank you.
Mr. Marsh,
Yes.
please refer to our planner by her surname
Oh,
as
sorry.
Ms. Knoll. Thank you. It's just a matter of respect.
Yeah, absolutely. Thank you. The unusual circumstances exception applies or doesn't allow you to use an exemption when there's a significant environmental impact caused by the unusual circumstance. And they say here, it's the prior oil spill that has resulted in this unusual circumstance. But what's important here is that the causal link has to be between the installation of the valve, that it's something about the valve that you're installing that is causing that unusual circumstance, or that is causing that impact. And in this case, the valves are only designed to reduce impacts and not to increase them. And just want to make sure I'm being responsive to the questions that were raised. I see we're at time. I'm happy to answer questions, but again, thank you for your time, and we're looking forward to your ruling. Thank you.
Mr. Marsh, I have a few questions
Okay,
of you,
sure.
if you don't mind.
Yeah.
And I appreciate your calm and reasonable presentation of relevant case law. And I think if you've been in this battle zone for 25 years, you've earned yourself a sabbatical. But regardless of that, I don't recall seeing in the record a brief or letter from you listing those cases. But is that something you could put together in an email, or even just send a list of cases that I could see to look at those things?
Sure, certainly.
I'd appreciate that.
Yeah.
And then that goes to timing. There's a deadline for installation of these valves that's in April. Do I have that correct? Or do I
April
not
1,
have it correct?
That's correct.
And what happens if you miss that deadline? I mean, if we take, if we don't conclude today, but we take some time or something, what happens to your deadline? Do you go to prison? What happens?
If I may, Chair, I would defer to my
Okay. And I have another sort of legal
Okay,
question, so
okay.
hang on up there. No, Mr. Gregg, why don't you go ahead and answer the question, but
Okay.
I don't want Mr. Marsh to wander out of the room.
Let me go to the mic so it's on
yeah.
record. Sorry. Yeah, Mr. Chairman, members of the commission. So the AB 864 did outline a schedule for compliance. Then each company that has assets that have to comply with those regulations submit a schedule. The first schedule, the deadline is April 1st of this year for installation. We're not going to meet that. We have requested an extension from the fire marshal. We are waiting to hear back. But that's the status. So at this point, we've submitted, we realized we couldn't get them installed. We submitted the applications in what we felt was an appropriate time to get them installed. But that's, answer your question is, we've submitted a request for an extension, and we hope that they'll approve that.
Okay, so back to Mr. Marsh. If the, and I don't even know which entity I'm talking about now, the applicant decided, we really don't want to waste money on these valves if we're going to go to a replacement line, what could they do to avoid that requirement? Would they have to declare abandonment of the existing pipeline?
I'm sorry, Chair, I'm not quite following your question.
Well, you might say, we really want to go forward with a replacement project and build that 12-inch pipeline, which I understand to be a different kind of pipeline. It's a high-pressure pipeline. Is that correct? Yeah, yeah. And, I mean, so it's kind of a different animal. But if you decided, yes, that's what we want to do, and we don't want to waste money putting in safety equipment on a pipeline that's we're not really using right now and don't intend to use, what could you do to get away from that requirement? Would you have to declare abandonment to the state of the pipeline? What would you have to do to avoid that cost?
Mr. Chairman, members of the commission, so maybe the best way to answer this, kind of start from where we are or what we've done in the past. So when Plains submitted an application to replace the entire pipeline back in 2017, that project, as I think Mr. Capella pointed out, is still in the process. One of in the consent decree that was agreed upon by a number of state and county and local agencies, there is provision for what happens in the future. So in the event that that line isn't approved, if certain conditions apply, it is outlined in the consent decree what would be required for restart. So at this point, Pacific Pipeline Company has purchased the pipeline. They are moving forward. They have contacted the county. The applications have been transferred to Pacific Pipeline's name with the replacement project. They are also doing their analysis of the condition of the existing line. One of the conditions or one of the criteria, both from PPC and for anyone that operates assets in Santa Barbara County, is to stay in compliance. One of the requirements of that compliance is compliance with regulations for AB 864. So just by doing this action, PPC is staying in compliance. That's the intent. Does that answer your question? Did that help with it at all? If not, I can try something else.
Well, sort of. It just seems to me that at some point there's a cost issue, and you might want to say, I don't want to do this. I'm going forward in another way, so why do I need to do this? I mean,
you're right.
I ride my horse around Las Flores Ranch, and I see all these cool old abandoned pipelines, and I'm sure not all of those have to have new safety equipment installed. So
Right, and this is not an abandoned pipeline.
Right.
This is an active operational pipeline. So that the difference is that at some point that decision may be made.
Right.
But at this point, Pacific Pipeline, and I don't know if, Brian, do you want to add to this, is that they are moving forward with both the replacement project permitting, which, again, started in 2017. It is unknown how long that will take,
Right.
and the analysis of the line. Let me have Brian see if he
So you really don't want to abandon this pipeline until that one's approved, right?
Mr. Chairman, that's correct. We do not want to abandon the pipeline right now. We've had the pipeline for 4 months at this point, right? So
Right.
we're just trying to get our arms around it. So we're taking what has been done up to this point, which are our projects through the county. We are evaluating the pipeline, the existing pipeline, and we're also moving aggressively forward on the replacement. So we're just looking at all options right now. But like Mr. Gregg said, to stay in compliance, we have to abide by AB 864. It is due April 1. We have had conversations with and letters to the fire marshal, just letting them know about status of permits and what's happening. But we're going to have that conversation with them because obviously we're not going to get it done by April 1.
Okay, well, thanks.
Yes, sir.
I'm done with my questions for now. May have a few more later.
If I could, just, Chair, if you'd indulge me for one clarification.
Okay.
Just on this issue of what's operational or non-operational, I want to make it very clear that that's a regulatory characterization that we've kind of bandied around a lot of terminology, but that's a regulatory determination that's going to be made by Office of State Fire Marshal or PHMSA. It's not a definition or a characterization that's going to be made by us or other agencies.
Right, and it's not a CEQA determination, is
Right,
it?
right.
Yeah, yeah. I
Thank
think
you.
we're on the same page there.
Thank you
Okay.
very much.
So, well, go ahead.
I'm
Mr.
sorry,
Green.
Mr. Chairman. I can add to that also. Mr. Marsh is correct. It is, if it's active, operational maintenance. People are using operational very loosely. The way operations of the pipeline doesn't mean you're just looking at the product running through the pipeline, right? There's many regulatory requirements that have to be met to operate the pipeline. Those include one-call responses, so if you want to go dig, out there and you call a number, then we've got to come out and make sure everything's safe. We got to do patrols of the right-of-way, so we're looking to make sure there's no encroachments, making sure that there's no harm on the right-of-way. When there's a big flood, making sure there's no washouts, items like that. So that's all involved with operations, and we have to continually do that as part of the regulation. It's not just running product through the pipeline.
Very good. Well, I'm going to determine that your comments have been in response to my questions.
Yes, sir.
So you'll have 13 minutes left for rebuttal.
Okay.
You'll have one more minute than the appellant, so use that extra minute very wisely.
Sir,
And,
thank you.
Or did you have something to add, Mr.
I
Green?
don't- No, Mr. Chairman, thank you. I guess, and you can take my 30 seconds off of our 13.
Okay, well,
I really do want to
We'll knock you
emphasize.
down to an even 12. then.
Okay, thank you. That way we're the same. I do want to emphasize that we respect the comments and concerns raised by others today. But as you've heard from staff and from us, that we are here to really focus on the impacts of the installation of the valves. And so we understand kind of the concerns that have been raised, but today's action is specifically to focus on the installation of the valves. And those are safety valves. Thank you.
Okay.
Any other questions before I step down?
I have one.
Oh, Mr. Martinez.
Yes, good morning. Okay, we have this compliance with AB 864, which is what application is in line with. If you didn't make this application, would you be in compliance with AB 864?
Sure. So there's AB 864, the regulations for AB 864 actually rely on each of the operators to prepare what they believe is best available technology. So this is the plan that Plains developed to present to the fire marshal, which they approved to meet those requirements. Pacific Pipeline looked at that and said, we can live with these requirements. There's no detail in the regulations that says you need to do this to comply. It's up to the applicant, it's up to the asset owners, the operators, to submit that plan that the fire marshal approves, which is why it's important in terms of the independent utility of the valves. As was pointed out, we were able to, Plains was able to actually relocate a valve that still maintained BAT, but was able to eliminate one of a potential environmental impact.
Okay, but
help?
it still remains unclear to me then.
I'm sorry.
If you didn't make this application, which you say has gone through some
Oh, I
processes
see.
here, and this April date goes by, then what would happen to the pipeline?
Sure. If the fire marshal will not to grant the extension of our request, then I would say that there would be a compliance issue. At this point, we are not out of compliance. The fact that we are in communication with the fire marshal makes me feel like we've had enough conversations. They understand the process in Santa Barbara. I believe that the action today is important. It's very important to kind of continue that schedule. But does that help? Does that answer your question? We are not out of compliance right now.
No, I
Give it a
understand
shot.
you're trying to be in compliance with AB
See if-
864.
Yeah, let me let Brian take a shot.
Yes, Chairman Martinez, let me just reiterate a little bit on that. So, yeah, we're in compliance with AB 864 through a document that was a risk analysis that was done by Plains and submitted. That was approved by the fire marshal. It include valves. It include more high-tech leak monitoring. It include automatic shutdowns, items like that. It was approved. We adopted it. We thought it was a very robust plan. But there could be other ways you can go about getting an approval, right? There's other pipelines that may just say, hey, we're just going to put leak detection in. and maybe that gets approved, right? But I think the point here is this is a very robust plan. You would want these valves in, right, in this system. And you wouldn't want to go down a path where you're trying to meet that regulation without the valves, to be honest with you. So I guess to answer your question, can you go back? Sure, I guess you can, and try to negotiate something. But at this point, why would you want to do that, right?
No, well, actually, that wasn't really my question.
Oh, I'm sorry.
And maybe that's my fault for asking the questions the way I do, but I'm just trying to figure out in my mind, and what you're asking for is the installation of these safety valves. Got it.
Yep.
And I got the fact that the installation of these safety valves is in line with the plan, the robust plan
Yes,
you
sir.
just described to comply with AB 864, correct? So we got that. And my sense is that if you don't have this plan, this approved plan, like is what I'm going to call it just right now.
Sure.
Excuse me if it's not approved or
Yes,
not,
sir.
but you would fall into non-compliance with AB 864, and there'd be
Correct.
ramifications for non-compliance, is what I'm getting at.
Yep.
And you're trying to avoid that right now, is what you're
We're trying to stay in compliance with the regulations. Yes,
Okay.
sir.
And what I'm trying to understand from you is what's your understanding of not being in compliance with AB 864?
It's a good question. I think it starts with a discussion with the regulatory agency, the OSFM. You know, if the reason we're not in compliance is held up due to permitting, that would be the discussion we would have with them, and we would see what latitude they have. But at some point, you have to be in compliance if it's an active line, right? So at some point, we have to get there, or we probably would be in non-compliance.
Thank you. I
Thank you.
understand.
Okay. Well, let's move on to public comment.
Mr. Chair, before we start public comment, I just wanted to, I think we have the housekeeping item. We did receive a couple of letters late. One of them was the letter dated February 28th. We received it overnight by Research Terra Mar. It's this top one I put on the dais this morning. And then the second one I noted to you when I sent out a couple of days ago. It is by, I just have this somewhere. It was the undated letter by the Wish-Toyo Shumash Foundation that I emailed to the Planning Commission Monday afternoon. So those letters were submitted after the noon deadline and are over a page in length.
Okay. For those of you who are not aware, we have a manual of procedures. That must amaze you that we follow a set of procedures, but we do. And it dates back, I think, to 2006. I found it in the bottom of my car the other day. And but it says that if we receive something more than a page in length after noon on the Monday before a hearing, it requires approval by the Planning Commission to accept that into the record. And it's a supermajority. It's 4 out of 5, I believe. Is that correct? Yeah. And so if somebody wants to make a motion to accept these items, then please do. I will tell you, because I have the mic, I'm not inclined to accept that myself, just because I haven't had any time to read these. And I think it's unfair, given all the effort from so many people to get everything in on time. But maybe you can convince me otherwise. So if somebody wants to speak up on the commission, yea or nay, now's the time. Well, I do not hear a motion to accept this, so we will not accept those items into the record. But we will go ahead with public comment. It's probably going to overlap the noon hour, so we'll go till around noon and take a noon hour. But let's get started. What I think I'll do is take 5 speakers at a time from live and from Zoom. If you can manage that, Mr. Villalobos. And we'll start with Mr. Steiner, who's sitting up there in our North County office. Oh, yes, and this is, what I want is the 1-minute people to go first, and I understand from Mr. Steiner that he was willing to go in 1 minute. I should have said that. But yes, we will have the 1-minute people go first.
Good morning, Chairman and Commissioners. Can you hear me?
Yes, Mr. Steiner, why don't you go ahead?
Thank you. I respectfully urge you to uphold the appeals and deny the valve upgrade project. The valves would neither remedy existing corrosion nor prevent additional ruptures. The catastrophic spill of 2015 has done more than enough damage to our county, its business interests, and the environment. The long list of Exxon's calamitous spills will doubtless continue to grow wherever it operates and regardless of its assurances and claims of engineering advances and safe operating practices. We ought not to be complicit by abetting corporate irresponsibility in our backyard. For decades, Exxon has proven itself to be an unwelcome neighbor. After spills, it finds ways to avoid responsibility for full cleanup and restoration. And especially considering the poisonous and carcinogenic nature of the materials here, recovery is never complete. I ask that you consider the values of the Gaviota Coast Plan and Exxon's historic record in your decision about reopening an unsafe line. Otherwise, the next ruinous Santa Barbara spill is surely only a matter of time. Your wise decision today would recognize staff report as dangerously myopic.
Okay, Mr. Steiner, you're well beyond a minute, so thank you so much for your comments. Who else wants to take a minute or less that's here in the room? I see 1, 2, 3, 4 hands. Would you line up in right there? And I guess you must be one of them? Yes. Well, why don't you go first? And you are?
I am Carolyn Cheney, and I represent the Live Oak Unitarian Universalist Social Justice Ministry. Climate justice is one of our religious principles, respect for the interdependent web of existence of which we are a part. We fully support the appellants and our allies of the Gaviota Coast Conservancy. As Mr. Capello and Ms. Diaz pointed out, this valve upgrade proposal clearly is an attempt either to reopen this old and decrepit line or to install a new one. We are highly disappointed with the staff report supporting the Pacific Pipeline approval. Another point I'd like to remind us is that the approval will allow the Pacific Pipeline to force landowners, reluctant landowners, to give up their easements. And I think that is reason enough to say no. I hope that I will be able to go to the climate meeting this afternoon at 12:30, the Santa Barbara County Climate Plan meeting, and report to them that the commission is opposing the plan and it will just say no to Pacific Pipeline. Thank you for your time.
Okay. Who's next?
Hi, I'm Angela. I'm just a Santa Barbara resident currently.
Angela, could you give us your full name?
Angela Hsu, HSU. I am in support of the appeals. I just found about this meeting like 2 days ago and am here and also very impressed with everyone. I support the appeals. I think I'm a transplant and I've lived here for 2 years and it wasn't easy at first, but obviously the most amazing thing about living here is the terrain and the scenery and the environment and the biodiversity and the communities and the diverse communities here. And so I'm actually moving in 2 weeks and I'm really sad about it and I love it here. And I'm 30 and I want to have kids someday, but you know, me and my partner are constantly debating the climate crisis right now, and we hope that one day we can come back here and bring our kids here, and we hope that the ocean, the land, and everything is protected. So I just ask that we do thorough environmental research and investigation on this and support the appeals. So thank you.
Very good. Thank you. Yes, sir.
Good morning. My name is Vincent Brock. I'm a community member. I've lived in Santa Barbara County for just over 10 years now. I would like to oppose the project here and just ask everyone to acknowledge or not be naive to the notion that these valves are not a part of a much larger story, of which there is a lot of history and context. First thing I'd like to mention is that if there is a potential spill or malfunction in the future, we're putting other local industries and businesses at risk. Why would we do that, and how is that fair?
Why don't you hang on? Let's
Sorry.
This morning?
We're having a glitch.
All
Jacob.
good,
I
all
don't
good.
want to interrupt your comments. With
Okay, I do.
I'll be brief.
Is that worked out? Okay. Should I start again yet, or wait?
I should have turned.
Should we go ahead, Mr. Villalobos? We need to wait on something. Okay. You decide if you want to start over again, because
Sure, thank you very much. I appreciate everybody's time here today as well. I'll just recap one thing of just the larger story here.
Yeah.
And there's context to that. On the larger perspective, in the future, if this helps create a spill or malfunction in the future, we're putting other local industries and business at risk. Like, why would we do that, and how is that fair to local businesses? If this wasn't an oil company or energy company, would we do it for another industry or type of business? Secondly, this isn't just about what the county might be able to gain monetarily if it's via tax dollars or not, but people are being paid to be here. Most of us aren't. And we bear the responsibility collectively to protect the most biodiverse marine area in North America. This is much larger and goes way beyond Santa Barbara. And the constituents of Santa Barbara County value that. That is innate in our culture. It's already heading towards destruction. We need to leave it alone. Thirdly, eminent domain. This isn't a highway or something that serves the public. It serves a private company in their interest. Fourthly, the EIR is 40 years old. Like, you gotta be kidding me here. And finally, if this gets approved, we're giving the benefit of the doubt to a business and industry that has historically not lived up to those promises. So thank you very much for your time. Those are my comments.
okay. Good morning. You ready to go?
Hello, my name is Vanessa Makhlouf, and I'm a part of UCSB's Environmental Affairs Board, and I strongly urge you to uphold the appeal of the Plains Valve Upgrade Project. Firstly, CEQA guidelines require the preparation of a subsequent or supplemental EIR if new information is found that shows the project will have new significant effects or introduces new mitigation measures. Also, the current analysis fails to take into account effects of the 2015 oil spill on the environment, while also ignoring new information on the corrosive nature of soil along the pipeline, and these mechanisms have failed. A full, thorough CEQA analysis must be conducted for this project, as the current analysis doesn't fully take into account new information that's relevant to the scope of the entire project. Thank you for taking the time to listen to my comment, and I strongly urge you to vote in favor of this appeal.
Okay, thank you. And here's our last 1-minute speaker that's here in the room anyway.
Hi. My name is Larry Bishop. I'm a retired hazardous material specialist with the county. And, but I mainly want to talk about a Buellton odor incident. I'm from the village of Honhoniata, which we settlers call Buellton. And it is about a few years ago, they were cleaning out the pipeline right next to a couple of blocks from my house, middle of the night, stable air, and it stunk up the whole west side of town. And they were cleaning out the pipeline we're talking about, and it was a big problem, and these folks really didn't understand what they were doing when they cleaned out the pipeline. I think you should reject the Exxon Plains pipeline restart proposal because the Refugio spill there's a significant, because of the Refugio spill, we see that there's a significant corrosion. The PHMSA report, 80 anomalies, pipeline mismanagement has been going on for 35 years. Smart pig monitoring, if it was actually done, the action would not have occurred. The new EIR is required. We need to follow CEQA, and most importantly here, we need to follow the county climate action plan, and this flies in.
I'm going to interrupt you. You've gone over 90 seconds.
I'm
so
sorry,
let's-
okay.
Let's
We
call
need
it
to
a day, but appreciate your comments.
Okay, thank you very much.
Is there anyone else in the hearing room that wants to take a minute and be done before lunch? Okay. And then, do we have folks on the Zoom call that are willing to go a minute or less? Mr. Villalobos, can you discern that?
So I'm going to just request a little bit of assistance for those who are attending via Zoom. I know that we have some hands up. For those who want to take the full 3 minutes, if you could just lower your hand for the moment and keep your hand up if you would like to just take a minute and go now. And I see we have 2 hands still up for that. So our first speaker will be Nadia Abushanab, to be followed by Brett Garrett.
Good morning, Chair Park and Commissioners. My name is Nadia Abushanab. I'm here on behalf of SBCAN, the Santa Barbara County Action Network. For 21 years, SBCAN has advocated for the protection of Santa Barbara County's natural resources, the promotion of economic and environmental justice, and sustainable communities for all. And SBCAN strongly supports the appeals of the valve upgrade project, and we urge the commission to deny the project or direct the applicants to conduct additional environmental review. Regardless of the technical status of the pipeline is not active and it should not be treated as such. It has been idle since 2015, and we don't agree with the baseline being an operational pipeline. It's unreasonable to expect that a pipeline could be idle since 2015 and there be no corrosion effects or no weathering that should be taken into consideration. And we think that the environmental review needs to be updated to reflect that. So thank you so much.
Okay.
Our next speaker will be Brett Garrett.
Good.
Oops, we lost you, Mr. Garrett.
Go ahead again. I'm sorry, Mr. Barrett.
I don't know what happened. I thought I was unmuted. My name is Brett Garrett, currently living in Goleta. I support the appeals. I oppose the project. The EIR said it would be safe, but it's wrong. The EIR doesn't even match the current conditions. It should have no standing because history proves that this pipeline is a disaster. And the EIR is ancient. It's obsolete from around 1984. And I'm hearing a lot of doublespeak that calls to mind George Orwell's 1984. I mean, active but non-operational, or was it the other way around? I don't know, but it's like, what? Let's be clear. The issue here is an operational active oil pipeline that they want to have. I'm appalled by the staff report suggestion that operation of the line is outside of the scope of the review, when it's obvious that the result of this project is going to be oil flowing and likely oil spilling. And even if it doesn't spill, contributing to climate crisis. The project is being justified by AB 864, but it obviously violates the purpose and spirit of AB 864. That's probably my minute. Thank you very much.
Okay, thank you, Mr. Garrett. Mr. Villalobos, why don't we select another 3 speakers from the Zoom list to go next?
And this would be for the full 3 minutes.
For the full 3 minutes, and could you call the names of all 3 so they're aware that they'll be following the next one?
Okay. So I'll start with those that have their hand up here. Maura Sullivan, to be followed by Ames Knoll, and then Andy Chow.
Hi, can you hear me?
Yes, please go ahead.
Thank you. Haku Mepchimawish, Mola Solomon, Klekenhi, Mitzkonakatan, Kup Ki Khaliki Shup, Kup Ki Sa Kaliki Shup. We will continue to protect our land. Thank you. Hello, everybody. My name is Maura Sullivan. I'm from Coastal Band of the Chumash Nation, one of the various tribes who deserve and need to be consulted on these ongoing projects. I was speaking our language, and I'm a linguist, and it's been very fascinating for me to analyze the way this meeting has been going in terms of, this is supposed to be accessible to the public, and it's so full of jargon that's completely inaccessible to many of the people who care about this project. And so for me today, I'm just expressing that I don't know exactly how to express, again, because the jargon is so complex, but I think what I want to say is that I'm against this project, and I don't know even how to phrase that, but I know earlier people were saying that they don't want or they are supporting the appeals, or, so it's, for me, it's very disheartening. It's very sad for me to try to express how I feel on this project. But definitely it's extremely concerning to see that CEQA, which is supposed to, as California people, protect our basic health of our human, animal, and plant populations. So I really urge the council to use the laws that we have as a state, as well as the laws that we have as county and city, to really, we are trusting you to watch and make sure that an EIR from 1985, when, gosh, I wasn't even born at that time. So it's just appalling for me to see that this is trying to be pushed forward. So I think I'm coming up on my time here, but I don't even know how to phrase that I'm against this project. So it's really concerning to see that these oil executives would just try to push this through. And I really urge the council here to also reach out and respect Chumash people. There are various Chumash groups. There's not just one, and we all deserve to be continually consulted on these projects. Thank you.
Okay, thank you for your input. And who's next, Mr. Villalobos?
I believe we lost Mr. Knoll, but our next speaker will be Andy Chow.
Mr. Chow, please proceed. Okay, we're not hearing from Mr. Chow, so we'll...
Okay. Do you want me to just keep going? Okay.
Yeah.
Our next speaker will be Jonathan Ullman.
Hello, commissioners, can you hear me?
Yes, please proceed.
Okay, I'm Jonathan Ullman. I'm the director of the Santa Barbara Ventura chapter of the Sierra Club. At the end of the day, at the beginning of today, what we're talking about is the pipeline, the Refugio pipeline that burst in 2015. We're talking about restarting it. All these efforts are towards restarting it. We have to make this clear to the public, to everybody. And I want to play you something from that day.
Mr. Ullman, I'm not sure what it is you're doing, but can you proceed in one direction or another?
Didn't you hear that?
No.
No?
Mr. Ullman, you were on mute previously, so you may just have to try it again.
Okay. You can, all right, I'm gonna play this for you.
Crude
Let me
oil
know if you
here
can hear.
on the coast, and there is still a lot of that oil.
Can you hear
right
this?
over the shoreline. Take a live look.
Yes.
You can see it covering all of the rocks here, but a lot of it has now moved offshore out into the ocean. Officials say they've already recovered 20 barrels of oil from the ocean, but there is much more after that pipeline ruptured. Thick black oil covers miles of shoreline in Santa Barbara County after a pipeline ruptures, sending thousands of gallons flowing out into the ocean.
Plains deeply regrets this release has occurred and is making every effort to limit its environmental impact.
Authorities discovered the rupture in the 24-inch line owned by Plains All-American Pipeline on the north side of the 101 freeway near Refugio State Beach just before noon. Residents complaining of the strong odor.
And when I got out of the car, I went, "Oh, Dave, what's that smell? Is there something wrong with the tent trailer?" He goes, "No, it smells like tar or gas or something."
Officials say the oil spilled into a culvert flowing under the freeway and emptying onto the beach and into the ocean.
Being a local, it's a disaster. You know, I learned to surf right here. So I can't bring my kids here for 6 months, maybe a year. I don't know.
Okay, I'm fast forwarding to the end so that you can hear.
Pictures from
Okay, 'cause your time's
newshawk.com
almost
show
up.
those birds that have been caught in the oil here along the coast. Now, the cause of that rupture remains under investigation tonight. As for the popular beach here, it remains shut down, and authorities say it likely will remain closed through the very busy holiday weekend coming up. Live at Refugio State Beach, north of Santa Barbara, Leanne Suter, ABC 7 Eyewitness News.
So sad. Leanne Suter, thank you for that live report. We begin with breaking news: an environmental disaster unfolding.
Okay, I think we're done, Mr. Ullman.
Thank you.
Okay, so our next speaker, we're going to go back to who's here in the hearing room. Paige Lund, to be followed by Bianca Barron.
Thank you. Hello, Commissioners. My name is Paige Lund, and I'm here on behalf of UCSB's Environmental Affairs Board. I urge you to support the appeal of the Plains Valve upgrade proposal. This proposal fails to comply with CEQA in numerous ways, notably exceeding the maximum pipeline length exemption requirement. CEQA states that for an exemption to apply, the project must be less than 8 miles in length. But this pipeline is collectively 123 miles long. While Plains argues that only the valve installation sections of the pipeline will count towards the 8-mile limit, it is not only a foreseeable consequence, but frankly inevitable that the entire pipeline will restart operations after the addition of these valves. The full 123-mile length must therefore be counted as part of the overall project. The proposal also fails to take into consideration current conditions and vital information that was not available in 1985, including the effects of the 2015 oil spill. The reopening of current non-operational lines threatens to result in both immediate hazards and long-term environmental impacts, such as air quality, water quality, greenhouse gases, potential oil spills, biological impacts, and loss of biodiversity. Moving forward with this proposal without a full and updated EIR, as required by CEQA, threatens the safety of our region and undermines the purpose of the review process. These impacts must be fully considered and evaluated before the proposal can move forward. Having grown up in San Luis Obispo, I distinctly remember the 2015 oil spill, an environmental disaster so impactful that its ramifications were felt within the neighboring county. The effects of this spill made an incredible impact on me as an individual, and as a voice for future generations, it is imperative that I help to ensure a catastrophe like this never happens again. Thank you for your time, and please vote in favor of the appeal.
Thank you. So next we have Bianca Barron, to be followed by Eric Ressel. And I may not be pronouncing your names right, but I'm following your own handwriting, so you just correct me if I'm wrong.
That was a great pronunciation. As you said, hello, Commissioners. My name is Bianca, and I am here on behalf of the UCSB Environmental Affairs Board, and I urge you to vote in support of the appeal of the Plains Valve upgrade proposal. The original EIR, written in 1985, does not consider new information, new consequences of construction, nor the effects of the 2015 oil spill. These changes should require an updated and significantly more credible EIR than the original. The 2015 oil spill was utterly devastating and deposited 142,800 U.S. gallons of crude oil into one of the most biologically diverse areas of the west coast of the United States. Plains was found criminally negligent in the spill, and moving forward with this valve proposal using an old EIR allows the company to pretend as though it never happened. Assembly Bill 864 was passed as a result of this spill and requires these valves, but it is intended to fit alongside robust environmental review, not function as a standalone fast track to restarting a still broken pipeline. A new EIR must be written before considering whether or not Plains can continue with their upgrade. As someone who grew up in San Diego and now goes to school at UCSB, I have a deep appreciation for the nature and the outdoors. Witnessing catastrophic oil spills in these communities is utterly devastating, and it is imperative these catastrophes do not happen in the future. For the health, safety, and longevity of our communities, please vote in support of the appeal. Thank you for your time and consideration.
Thank you. Okay, next we'll have Eric Bressel to be followed by Tori Cutbirth. Is Eric here in the room? Eric left? Okay. Do we have any idea whether he's coming back? He's not coming back. Okay. And so Tori Cutbirth to be followed by Brady Bradshaw.
Good morning. My name is Tori Cutbirth. I'm 29 years old, and I grew up here in Santa Barbara. I went to Roosevelt Elementary School, Santa Barbara Junior High, and Santa Barbara High School. I joined thousands of community members as a part of the Central Coast Climate Justice Network, Community Environmental Council's Climate Stewards Alumni Group, and Santa Barbara City College Environmental Horticulture Department. I also work in local environmental philanthropy. I urge you today to please vote in favor of the appeals and deny this project for our community. Precedents have been mentioned a few times today, but we are in unprecedented times. We are facing climate disaster, and our futures are at stake. Our children are at stake. We are already experiencing climate disasters in our community, fires and floods, and 40 families in Guadalupe that just lost all of their homes and are living in farm worker housing because of climate change. And I cannot stand here today and listen to these big oil companies who come into our communities and this city and county staff who want to support this project when our lives are at stake. When our local species not only read the red-legged frog, but our bottlenose dolphins, our monarch butterflies, our beautiful indigenous people who have called this land home for thousands of years. I beg you to end this today. I beg you to end this today. I have the privilege to work in philanthropy and work with this incredible group of climate activists and stewards and environmentalists who work tirelessly year-round to protect our local environment and our community members, our children, our grandchildren, our neighbors, our community, our teachers. Thank you for allowing me to share today, and I apologize if this is not appropriate to cry passionately at a hearing, but I cannot stand any longer for fossil fuel companies to ruin and destroy the place that I call home, that my 15-year-old nephew is sitting in class at Santa Barbara High School and cannot be here today to beg you to protect them. The whales and dolphins and beautiful nature and habitat that call this home, who cannot be here today to beg you to protect them. That is what is at stake today, not just a valve. There is no safety. There is no safety with fossil fuels, and that is what I'm here to beg you today. So I thank you for your time, and I thank you for your consideration.
Thank you, Ms. Cutbirth. Brady Bradshaw to be followed by Tevin Schmidt. Is Brady here? There you go.
Wow. These kinds of consistent actions from major oil companies numb me a lot. So thank you for that emotion. having to fight this for the last decade plus. I'm a senior oceans campaigner with the Center for Biological Diversity, where my life's work has been focused on preventing oil spills like the one I witnessed firsthand in the Gulf of Mexico in 2010. I witnessed dolphins and whales swimming and drowning in crude oil directly. And since the 1969 spill here in Santa Barbara, there have been at least 44 major oil spills into U.S. waters, each of them over 420,000 gallons. And the federal government reports thousands of routine spills every year. If not today, at what point will this commission have the opportunity to address the impacts of allowing this decrepit pipeline to transport oil from 3 decaying 1980s offshore oil platforms that will almost certainly spill into the ocean, or from the pipeline into the soil and water onto the beaches? These impacts are reasonably foreseeable and should result in the denial of any project associated with this pipeline. The offshore section of the pipeline is also a major liability. One offshore pipeline study found that after 20 years, the probability of failure on offshore pipelines increases between 10 and 100% per year. The age of infrastructure is a critical factor, and installing valves won't fix these problems. It will only give a false sense of security while the pipeline continues to corrode in the soil. The incident report from 2015 details inadequate cathodic protections and other corrosion protections, and the line has been decaying since then. Again, the bottom line is that this trash pipeline needs to be retired and cleaned up, but at the very least, the Commission should thoroughly weigh and consider the changes to the pipeline's condition in the time elapsed since the spill. Exxon plans to sell this junkyard pipeline to Sable. It's unlikely this company can be held liable, considering the owners of Sable's last company filed for bankruptcy. It seems to me critical that to understand the operational and financial risks associated with awarding permits that will eventually be passed on to companies like this. Fossil fuel companies like the applicant are driving the 6th mass extinction on planet Earth through rampant climate warming emissions. I hope this commission will also consider the operation's contributions to Santa Barbara's climate impacts and the resulting vicious cycle of fires and mudslides. Exxon should not be allowed one more inch of land beyond its original right-of-way in the land grant area of Nuestra Señora del Refugio, where Chumash peoples and the Ortega family have legal authority. This commission should be wary when considering granting oil companies permission to expand operations on treaty lands. Santa Barbara residents and decision makers have a moral right, after everything residents have experienced, to hold these polluters to the highest standards of critical oversight. Please grant the appeals. Thank you.
Thank you. Tevin Schmidt? Is Tevin Schmidt here? Okay. Mr. Woodbridge, are you here in the audience? Are you still willing to hold to a minute? Okay, you're going to be next, okay?
Good day, Planning Commissioners. My name is Tevin Schmidt. I'm the watershed scientist for the Wish Toyo Chumash Foundation. We thank you for holding this public hearing for the appeal of the zoning administrator's decision on the valve upgrade project. Wish Toyo strongly opposes the Santa Barbara County zoning administrator's approval of the project and requests that the project is denied for the failure to meet environmental review requirements under the California Environmental Quality Act. The valve upgrade project does not meet any of the definitions or requirements of the statutory or categorical exemptions detailed in the applicant's notice of exemption. This project seeks to transport crude oil through a heated pipeline that ruptured and caused a massive oil spill in 2015. This pipeline is no better shape than it was in 2015, with the 901 and 903 pipelines experiencing significant metal loss and external corrosion. There has been an additional 8 years of corrosion and exposure since this spill. This project therefore includes at least 72.6 miles of pipeline and does not meet requirements for the 8-mile exemption. The risk of oil spills caused by the corrosion of this decrepit pipeline disqualify this project for the remainder of the statutory and categorical exemptions. This project threatens cultural resources and Chumash lifeways of Southern California coast and Santa Barbara County, including the traditional fishing practices, ceremonial use, tending and gathering, and cultural practices of the First Nations peoples that depend on these lands and waters for the continuation of their culture. The project may result in substantial negative impact to at least 22 endangered species that were not even listed yet or considered in the 1983 EIR. The project will continue to threaten Sandy Beach, rocky intertidal, benthic subtidal, kelp forest, and rock reef habitats of the Southern California coastline. The pipelines also traverse the San Ynez and Sisquoc rivers, which host important recovery habitats for the southern steelhead, California red-legged frog, two distinct populations of the California tiger salamander and southwestern willow flycatcher. The County of Santa Barbara cannot allow this project to move forward with the necessary environmental review. The project, as it is before you, must be denied. Thank you for your time and consideration.
Thank you. Mr. Woodbridge?
Chairman Parks and Commissioners, thank you. David, I think, has a photo that I sent him last night that he can pull up. Pictures worth 1,000 words. It is a photo that was taken by a county staffer of the condition of the pipe. As soon as that photo comes up, there it is, yeah. Yeah, a 10-year-old could look at this decaying, corrosive pipe and tell you that the moment something is sent through it, it's going to leak. It's not rocket science. Look at the condition of that pipe. Putting lipstick on a pig doesn't change it. It's still a pig. This is comparative to putting new tires on a semi-truck and trailers that has decrepit, old, rusted out brakes, putting it on the freeway at 60 miles an hour and seeing how fast it crashes. I don't know what the alternative motives are for putting valves on this decrepit pipeline, but it makes no sense. I can't believe they're going to spend the money to do that or want to. Thank you very much.
Thank you, Mr. Woodbridge. Mr. Villalobos, how many more speakers do we have left on the Zoom call?
We have at least a half dozen.
Okay. Here's what I'm going to do. We have 2 left here in the hearing room. I think it's harder for folks literally here to take a lunch break and come back. So what I'm going to do is hear these 2 that are left in the room, and then we'll take a lunch break, and then we'll get back to the Zoom people. So the 2 left that I have is Catherine Lane, I think it is, and Suzanne Singh. Catherine, Suzanne, are you here? Well, she wrote it as Catherine.
Good afternoon, Planning Commissioners, County staff, appellants, and applicants. Thank you all so much for your time and energy and for letting me speak today. My name is Kat Lane, and I am an Executive Chair for the UCSB Environmental Affairs Board. I am here today to urge you to vote in favor of the appeal of the Plains Valve Upgrade Project. Current environmental review from 1985 and the addendum does not consider the impact of the whole project, namely reopening and replacing the lines in addition to adding the valves. The original review also does not take into account environmental effects of the Refugio oil spill in 2015, which have altered the conditions surrounding the pipeline. Although installing valves may add a theoretical element of safety, it does not solve the existing corrosion problems with the pipeline valves, along with which will not make this pipeline functional in the first quarter of January 2024, which the operator lists in its investigator filing with the SEC as its planned start date. I would encourage any of the applicants who are still here today who want to argue in favor of this valve update going forward to only see it in terms of valves and to not see it in terms of a pipeline, to take a much-needed trip to the wonderful vision clinics that exist in Santa Barbara. This is far more than just looking at the valves. This is the reopening of a pipeline and the restarting of offshore oil in Santa Barbara. To say different is to proceed forward with blindness and not in good faith. Santa Barbara is a home to beautiful beaches, a diverse coastline that deserve our stewardship, our integrity, and our listening to the indigenous peoples who have long been stewards of this land. Oil companies continue to infiltrate and to make their presence known by vicious attacks upon bills which are meant to uphold the integrity of our environmental community, not to disgrade them in such a disrespectful way. The valve proposal is casting itself as innocuous, without recognizing the deadly implications of restarting the line and offshore oil rigs. Thank you all so much for your time and for listening to me today. I appreciate your consideration greatly.
Okay, Suzanne Singh.
I don't know if I should say good morning or good afternoon or right at the tip right there. My name is Suzanne Singh, and I'm the Economic Development Director for the Santa Maria Valley Chamber of Commerce. And I come to you just to speak on our behalf and just give you a few of our points that we've noticed with this process. We truly believe that businesses with existing investments are entitled to maintain their assets within state and federal laws and regulations. I think county planning staff have completed significant analysis over nearly a year and presented to the zoning administrator, who appropriately approved those permits, especially those required to comply with regulatory obligations. Upholding this appeal will have broader implications in the business community that the Planning Commission does not support the existing ordinances that allow businesses in this county to function appropriately. I hope you will just deny the appeal today. Thank you.
Thank you. Okay, we're going to take a lunch break now, and we'll resume with public comment. So those of you that are on Zoom will be with you, and you should be ready to go at 1:10. Okay, welcome back to the County Planning Commission hearing for March 1, 2023. We're on item number 1, and this is our afternoon session. So where we are now, I believe we're still in public comment, and we have some Zoom speakers. So let's handle them, and then we have 2 additional slips for people here in the room, and we'll do you after we handle the Zoom speakers. So we'll probably be another half an hour or whatever it is in public comment.
Our first speaker will be Charisse Cordero, to be followed by Tony Frohoff.
Just go ahead.
Hello and hello. Can you hear me?
Yes, please go ahead.
Thank you. My name is Charisse Cordero, and I'm a concerned citizen and a member of Santa Barbara Standing Rock Coalition. I agree with one of the appellants that the only reason for these valves, it doesn't make any sense to install them except as a prelude to a restart. You've heard multiple reasons from a host of people about why this cannot happen. This pipeline is unsafe and unsound. I support the appeal, and I urge the Planning Commission to deny the project. Thank you very much.
Well, thank you. And who's next again?
Tony Frohoff.
Yes, hello. I'm sorry, I can't seem to have the video, or do you even want video?
That's disabled for public speakers. Just go ahead with your comments.
Okay. My name is Tony Frohoff. I'm an internationally recognized scientist in the conservation of whales and dolphins. I'm here on behalf of the nonprofits Terramar Research and Protect Our Dolphin Neighbors of Santa Barbara. We most urgently support the appeal to stop the Plains Valve Upgrade Project. Please don't roll out the red carpet for what are guaranteed to be further unnecessary, reckless, and irreparable disasters to befall our community that you are beholden to protect. It is egregious that these companies even have the audacity to request use of a pipeline that is now even more outdated and dangerous than it was when it caused the 2015 Refugio oil spill. Can we please learn from these mistakes and not knowingly put Santa Barbara in the path of such irresponsible danger? Thank you.
Our next speaker will be Dustin Hoyseth, to be followed by Jeff T.
Can you hear me?
Yes, please go ahead.
Sorry. My name is Dustin Hoyseth. I'm Public Policy Manager with the Santa Barbara South Coast Chamber of Commerce. And the Chamber would like to urge you today to uphold the previously approved permits. We believe that our local businesses are entitled to maintain their local assets. And we feel that it is crucial that the Planning Commission supports the work of county staff in this regard. It is important to note that most counties in California, the administrative process for reviewing and approving such actions takes only weeks or at most months. In this case, the county planning staff has completed significant analysis, and we feel it is appropriate to approve these permits and move forward, especially those required to comply with regulatory obligations.
Oops, we lost you, Dustin.
Mr. Hoyseth, it looks like we lost your mic.
Well, can you hear me now?
Yeah.
We can. Go ahead.
Okay, I apologize. If the Planning Commission chooses to overturn the zoning administrative decision and uphold the appeal, we feel that this will have broader implications throughout the business community, and we're worried and concerned about the precedent that this would set. This decision will communicate that the Planning Commission does not support existing ordinances to allow businesses in this county to continue functioning appropriately. Therefore, we urge the Planning Commission to support the work of the county staff and uphold the approval of these permits. Thank you for your consideration.
Our next speaker will be Jeff T., to be followed by Patrick Watson. Jeff T. or Mr. T. If you could unmute yourself. Okay, let's move on to Patrick Watson. All right, Mr. Watson, if you're not there, we'll move on to Tracy Nunez. Why not? We'll try Andrew Chow again, who we tried before lunch. Mr. Chow, Mr. T, Mr. Watson, or Ms. Nunez, if any of you are there, go ahead and unmute yourself. They may just be listening.
Okay. And do we have anybody else left on Zoom?
Yes, I just saw
Oh.
one more. Anna Eisenberg.
Yes, I can give my comment now.
Go ahead.
Good morning, commissioners. My name is Anna Eisenberg, and I'm here as an advocacy co-chair of UC Santa Barbara's Environmental Affairs Board. After significant research, we strongly urge you to support the appeal of Plains All-American's proposed valve upgrade project. Firstly, CEQA states that the full analysis of all foreseeable environmental impacts of a given project must be presented in an EIR. As it makes little sense to upgrade valves on an abandoned pipeline, it's reasonable to assume that the proposed project is intended to support a larger project. The revival of pipeline operations, with the full extent of this project taken into account, CEQA guidelines clearly apply and therefore require Plains to present a full EIR that considers the implications of a fully operational pipeline. Additionally, CEQA requires an upgraded EIR to be prepared should new information regarding the project surface. The original EIR for this project was prepared over 35 years ago. In the 3 decades since, the environment of that area has shifted substantially. Changes from a variety of factors, including the 2015 Refugio oil spill, must be carefully assessed in a new EIR before this project is allowed to proceed. As a first-year student at UCSB, I feel increasingly grateful for the opportunity to experience Santa Barbara's unique natural landscape. Yet this valve upgrade proposal and subsequent revival of the pipeline pose significant long-term threats to the local environment. Commissioners, for the health, safety, and education of curious students like myself, I urge you to support the appeal of Plains All-American's pipeline proposal. Thank you for your time.
Thank you.
All right. Ms. Eisenberg was our last speaker on Zoom.
And these others, are they able to join on?
If I've left them able to speak this whole time, so we can give them one last shot. Mr. Chow, Mr. T, Mr. Watson, and Ms. Nunez. If any of you are listening and wanting to speak, go ahead and unmute yourself.
Or forever hold your peace. I now pronounce you. Okay, we have 2 speakers here, Gabriel Frosto and Luke Karras. You folks here? Then how about Mr. Frosto first? Okay. And then Mr. Karras.
Haku, Maktuka, Pahawa Altomochich, Kashjo iti hineke. Your Honorable Chairman, Commissioners, my name is Gabriel, and we are glad to have you here, and we are glad to be here in a good way. We are still here. I am the tribal chair for the Coastal Band Chumash Nation, and I've come today in supporting the stop of the capping, the well work, the pipeline, and I'm in opposition. The Coastal Band of the Chumash Nation has maintained a stance against these procedures, and we still do today. We have historically, and we will for all future generations. Our continuing ongoing stand against Exxon and its unethical practices and procedures, it's a huge situation, and it's much deeper, it's much more involved than any of us can really realize here. I've worked in decommissioning sites in the past here on the Gaviota Coast. And what really grabbed me is that we used these outdated environmental reports. We did. I was a part of those projects. And, you know, to at one point in time, I almost thought that they would actually work. I thought that they would suffice. The information was there. My family was on the historical reports. I was glad to be there to be a part of the process. But unfortunately, those reports failed. They failed them. They failed us all. Being a tribal member, being a Chumash man, having my ancestors here, having my ancestors and my relatives on the historical report, I was so deeply invested emotionally, spiritually, physically to the process of being optimistic in restoration of these places. But as I observed the process of the decommissioning of these sites, I realized there is no restoration. There's no healing. You can't come back from this stuff. You know, they said that these grounds they'd been disturbed so many times, there was no way that any other further ground disturbance on already worked soils would reveal culturally sensitive materials, right? There wouldn't be any kind of further damage environmentally. But we found pockets of oil, the old way they used to dispose of oil, right? They dig holes, pour the oil in there. It stayed in there in a staging station for a while. Then they remove it. But did they really remove it all? No. What was this entity going to do about it? Just throw the dirt back over it, we'll mark it. We did our best. So what is our best? You know, how does a corporation or entity like Exxon do their best? Is this their best? Honestly, using capping. How about putting these valves in? What's the real story behind that? Do we use the valve opportunity to keep it alive long enough to hand it off to the next guy? Come on. What are these valves going to do for that pipeline? That pipe, it's going in and remodeling a house and getting up to code standards. We all know what we have to do, go to the building department to do that. We have to have the most updated, stamped engineer on those sets of plans. You cannot remodel a house and add additional weight to the roof and put a second floor on without inventorying the existing structure and retrofitting a slab to bear the weight. This pipeline cannot bear the weight of further use. These valves are just an excuse to carry on the work, to pass on to the next guy, to sell this project. That means nothing to me at this point. What means the most to me is that we do our due diligence. I have to do my due diligence. We're supposed to be consulted with under the AB 52 Act. This business is trying to avoid CEQA. CEQA was put into place to protect us. The AB 52 legislation was supposed to protect environmentally sensitive areas, culturally sensitive areas. Why do we want to push this through so quick? Why do we want to avoid CEQA? We know why. If CEQA is recognized, if the environmental impact reports are put in, the cultural resource reports are turned in, this thing's dead in the water. So again, I stand with the Coastal Band Chumash Nation. I am their civil servant. I'm a servant to my community, our tribal community, our local community. I belong to our community as a whole. We need each other as a whole. I'm going to make an offering today, and I'm going to continue to pray for these lands of our ancestors, these village sites. I'm working with NAGPRA Repatriation. I've handled over 2,500 bodies of my ancestors, babies, hands, wrists, legs. Repatriation, what does that mean? Taking something out of the ground and then having to ask for permission to put it back? Have any of you ever held the remains of your ancestors? I have. There is nothing more painful, Mr. Chairman. Nothing, commissioners. I'm broken for my people. I will be strong for my people. I'll be strong for us. We need each other. And we have to make a stance. We do.
Mr. Frosto.
Thank you.
I really appreciate you coming today and expressing your perspective. And I'd love to have a long conversation with you sometime, but today, as chair, I've got to
Yeah, I
move
appreciate
along.
that. I try to do the same thing in my meetings, and somehow we end up going an hour over. Can't get the agenda done. Anyways, thank you for your time, Mr. Chairman, commissioners. Blessings to you all. Blessing to your relatives. Gastro.
And let's have that long conversation someday. I'd like to
Please, let's
that.
do. I'd love to.
Okay. Mr. Karras, you ready?
Hello, Commissioners. My name is Luke Karras, and I'm here on behalf of the Sunrise Movement and as a concerned Goleta citizen. I urge you to vote in support of the appeal of the Plains Value Upgrade proposal. The plan to install valves along what is currently an unused and corroded pipeline clearly, to my mind, represents the first step towards its restart. It does not make any sense to me to invest time and money to install new valves without the end goal of renewed use. If oil is transported along the pipeline once more, even if significant upgrades are made, we risk another catastrophic oil spill. We need to look no further than the spill from 2015 to see how dangerous this pipeline can be. This spill deposited over 100,000 gallons of oil into the nearby environment and even infested the ocean near Refugio State Beach. According to the Refugio State Beach oil spill damage assessment prepared by multiple state and federal agencies, 1,500 acres of shoreline habitat were impacted, 2,200 acres of subtidal habitat were impacted, hundreds of marine and bird species were killed, and many more species were negatively infected, without talking about the human cost as well. As I'm sure everyone here knows, the Gaviota Coast is a natural marvel that lends so much beauty and character to our community and must be protected against further oil devastation. Thank you for listening to my comment, and please vote in support of the appeal.
Thank you, Mr. Karras. Mr. Villalobos, do we have any other public speakers?
Mr. Chair, no.
Okay. Well, let's go on to our rebuttal presentations, and this would be appellant's turn. Mr. Capello. 12 minutes, yeah.
I'm looking at about 6, so if you could use that as my clock, maybe 7.
Sure.
And then my colleagues here will pick up the rest, all right? First, Plains promises. And why do I talk about Plains? Plains came to this community after the oil spill and said they would make good. This was a terrible thing that happened, and they would make good. They did not make good. Plains then sold the pipeline to Exxon subsidiary, Pacific Pipeline. And you are getting different stories from the people here today. Who is the end user? The lawyer for Pacific Pipeline say the end user is not important. The end user is not important on a facility such as this? You don't want to know who is responsible for the next disaster? You, as planning commissioners, are going to vote on something when they're telling you, don't worry about the end user, because their promises are hollow. Exxon made $44 billion last quarter. That's net profit. I'm not talking assets. They got the money to do this right. And when I heard that Exxon was coming in and taking over the pipeline, I said to myself, well, that might be a good thing. Exxon's been trying to get a trucking proposal through. They couldn't get it through. They can't barge it. So now if they do this pipeline right, they can use the Santa Ynez unit. We represent oil workers, 150 of them that lost their job. That's what Plains did. It devastated the oil industry. You folks in Santa Maria and Lompoc had lots of my clients who lost their homes because of Plains. And by the way, Plains has refused to pay them any money. We have to sue them for their loss of jobs. Well, I heard the Santa Maria Chamber of Commerce lady get up here and talk about, oh, we've got to protect existing businesses. Mr. Toutram, who is here, his family has been in that ranch since the 1870s. It's the longest. We represent cannabis owners, vineyards, a sports club, ranchers, lettuce growers. We represent every ranch between here and Pentland. Why aren't they part of the Santa Maria Chamber of Commerce, and why aren't they being protected? I was outraged by those comments. You know what's important today? What's important today is that you find out who your end user is, and then you find out what the project is. Because these guys, their job is to get something for whoever it's going to be. Let the Santa Ynez unit play out. That's the 3 platforms that are left. And goodbye, Santa Barbara. Just like Plains. Do you know that Exxon sold the platforms to Sable with a take-back loan? But Exxon's getting out of the county. Plains got out of the county. They left the squid industry dead for 5 years. Wound up, they had to pay $180 million for it, but we had to sue them for 7 years in federal court. Don't tell me about the businesses. The businesses are devastated, and that's why when you see a project like this, it becomes critically important to understand what's going on. One of those young people from UCSB, God, I love those kids. I just really love them, said, you know, this law was passed, ladies and gentlemen, to protect the environment, not to use it as a trick to get these people to get this particular project through without any environmental impact report. The idea of having automatic shutoff valves is so that you don't have another oil spill. But if they're using it as a guise for this pipeline that's in the ground already, which is a Swiss cheese, it's a bait and switch. Are they doing the new pipeline project? You couldn't get an answer from Mr. Gregg on that. Oh, yeah, well, that's going through the process. Well, but that requires full EIR. They may not want to do that because if they can get this through on this gimmick, why not just do a little Band-Aid job on this pipeline? Maybe 5-7 years, Santa Ynez unit plays out. Sable only owns the 3 platforms in this pipeline. They're not a pipeline utility. They have no eminent domain authority. They're not buying this land from us, but with eminent domain. They are not a utility. A utility is a company that moves moves oil and gas for a variety of customers. They got one customer, Exxon. They are not a utility. And my clients are saying, you want to come back on our land for 18 to 24 months, and that's what the original project was, 18 to 24 months. They were going to dig up the farmland lands, the vineyards, et cetera. We said, you got to buy a new easement. And Plains went, oh, we don't have to buy a new easement. We already have an easement. And we said, no, your easement says it's been abandoned. You didn't maintain it and it's not operational. And that's what that lawsuit's all about. So, ladies and gentlemen, when you talk about non-operational and you hear what your planner here said, just look at page 6 and 7 of my presentation and read the PHMSA report. You may not operate this pipeline. You may not restart this pipeline without our approval. That's what they've been told. It is non-operational, and it cannot be operated. And the only way you're going to protect this county and its businesses, et cetera, is to deny this appeal. Thank you.
Good afternoon again. Jessica Diaz, Brownstein Hyatt Farber Schreck for the appellant Gray Fox LLC. I think I'll take the rebuttal time to take it back to CEQA and address 3 points and attempt to address some of the arguments raised by our very skilled CEQA practitioner, Mr. Marsh. It's good to see you. The 3 areas I want to address are the age of the EIR, the baseline issue, and the key question here, which is, what is the scope of the project, again, that the county is required to evaluate? So on the age of the existing EIR, I want to address briefly a case Mr. Marsh cited, it's Committee for Progressive Gilroy versus State Water Resources Control Board, 1987. So I suppose at most this case stands for the proposition that there is no bright line rule about when you have to toss your EIR in the garbage can, like expired goods in your refrigerator. But we do have an actual legal standard that we can adhere to, and that's provided in Public Resources Code Section 21166, requiring a subsequent EIR when certain conditions are met, such as substantial change in circumstances or new information. In the Progressive Gilroy case that Mr. Marsh cited, the plaintiff group did not even claim that these triggers were met. Therefore, that case is completely inapt here. Here, we not only have evidence of new information and a substantial change in circumstances, but this is actually a model case study for the triggers that would require the county to do a subsequent EIR under the statutory standard. Second, on baseline, there's been a lot of discussion about whether the pipeline is operational, non-operational, active, idle, et cetera. And Mr. Marsh made the statement that the baseline is a that the baseline is an operational pipeline under what he described as settled CEQA case law. Unfortunately, I haven't had an opportunity to review the legal authority he's referring to, but I can tell you that that statement is directly contradicted by the county's own notice of preparation published in April of 2022 for the Plains Pipeline Replacement Project. That was a revised NOP, again, regarding the EIR that was going to be prepared for the replacement lines. And that NOP actually said that the baseline that was originally envisioned for that environmental document, which was going to be an operational pipeline, had changed because the existing conditions continued to be, and I quote, a non-operational pipeline. Well, if a non-operational pipeline is the proper baseline condition for this other project that the applicant is pursuing to replace the lines, it is completely illogical to say that, well, planning commissioners, for purpose of the valve replacement project, you need to look at, wind the clock back 7 years and look at what conditions were on the ground then, which was oil flowing through the pipeline. Finally, CEQA review must include an analysis of the environmental effects on a future expansion or action if it's, quote, a reasonably foreseeable consequence of the initial project. That's from Laurel Heights Improvement Association versus Regents of UC, 1988, 47 Cal 3D 376, Pin Site 396. This was the seminal piecemealing case. The applicant does not get to tell you what the scope of the project is. CEQA does. It is abundantly clear from what the applicant has said today that resuming operations of the pipeline and actually using it to convey petroleum is a reasonably foreseeable consequence of the valve replacement project, and the county is required to look at the environmental impacts of those reinstated operations. Thank you.
So appellants, you got a couple of minutes left. Ms. Citron, were you going to make comments? Go for it.
Well, I would just add that that the counsel for other appellants have done such a good job in their rebuttals. I don't know that I have anything to add, but I would just reemphasize the importance of the subsequent review provisions in CEQA, and that here we have unusual circumstances, or changed circumstances rather, and unusual, and new information. The pipeline that lies in the ground today that will be used with these valves is not the same pipeline that was described in 1985. And you know, I hope you've had an opportunity to review the PHMSA report. It was attached to Mr. Capello's letter. It is very informative, and it it details the corrosion issue, which is an external corrosion issue. It is something that transpired between 1985 and 2015. It's not an issue of what has happened since 2015, but rather what has happened since 1985. And it's clear that this pipeline, in its current condition, without protection from external corrosion, and these are corrosive soils that it is in, that is a safety risk that you must account for in your environmental review. And the 1985 EIR and addendum are not adequate for that purpose. So we really appreciate your consideration of this project, this appeal. They're really important issues that really range the gamut from landowner concerns to environmental concerns to, existential concerns about climate change. And there's a lot on your plates, but I trust that you will consider all the information brought forward and make a good decision. And we would ask that you uphold the appeals and deny the project, or send it back to staff to prepare a subsequent EIR. Thank you very much.
Thank you. Okay, now we're on to applicant's rebuttal time. And Mr. Gregg, are you ready to start?
Mr. Marsh can start.
Okay. And Mr. Marsh, 12 minutes total for applicant's rebuttal, whether it's you or other people.
Thank you, Chair. I'm going to be very brief, and then I'm going to hand it off to my colleague. So first, I just wanted to raise a couple of, or address a couple of the issues that Ms. Diaz raised, and I'll take those in reverse order. The first is on the scope of the project and this notion of piecemealing. And to try to put it in simpler terms, if you're trying to build a target and you know that you're going to need access for that target, but you don't include the road, then in your environmental impact report, that's piecemealing. On the other hand, if you already have a target and you've got the road, but because of a new law, somebody requires, perhaps the Planning Commission requires a new access point for fire safety, and you got to go put in a new road. That is not piecemealing, and that is exactly what we have here, where because of state regulation, we're now having to upgrade the lines that are already existing. On baseline, and Chair, you gave me some homework. So I came back with a section of it's actually the Koskoziski practice guide under CEQA, or for CEQA. It's a legal treatise that a lot of us rely on. The California Supreme Court has often cited it. And it's in discussing the baseline in relation to subsequent review, which again is distinguishable from a new review of a new pipeline or new review of trucking. It says, and I quote, "When an agency is evaluating a proposed change to a project that has previously been reviewed under CEQA, the agency must apply CEQA standards limiting the scope of subsequent environmental review. And thus, therefore, under the circumstances, quote, the baseline for purposes of CEQA is adjusted such that the originally approved project is assumed to exist." And these cite to several cases, and I'm happy to make those available to your council. And with that, I'm going to hand it back to Mr. Gregg, and I appreciate your time. I'm here to answer any questions if you need.
Well, Mr. Chair, members of the commission, thank you again for the opportunity to let you hear our position on this and take the time and the thoughtfulness that you have. Let me close with the following points. First, to make it clear, PPC, Pacific Pipeline Company, is the owner and will comply with all laws, rules, and regulations, which is what it's trying to do with compliance with AB 864. Any comments regarding potential subsequent owners and investor presentations and any comments about prior owners, actions that are really irrelevant to the valve project application to meet safety standards. Next, as county staff and county council have determined, this is not a decision about reopening the line or a decision on restart. This is a decision on installation of safety valves to comply with AB 864. AB 864, which is the bill that was authored by First District Williams when he was in the assembly. It is to reduce the impact of a potential release from any pipelines in the coastal zone. Interesting legislation that was supported by some of the environmental organizations that are in the room today. With respect to landowners' rights and easements, those landowners or their predecessors already granted easements, which are of right. And so, respectfully, this is not forcing anyone. But this is a public utility, and yes, eminent domain is a last resort option. With respect to Commissioner Martinez's question, we believe we would be out of compliance if we do not do anything. We have an approved plan to comply with BAT, but you are correct. This is about compliance. County staff with county council, with consultation with county council, has thoughtfully reviewed the EIR and the addendum and evaluated the project. It's been over a year in the process. Accordingly, we agree with county staff and submit the EIR and addendum as sufficient for this valve project. No additional secret review is required. With respect to status of the lines, the pipelines are intact. They are holding pressure. As stated before, today is not a vote for restart. It is a vote for safety valves and installation of a discrete project. Further analysis and work will be done with Office of the State Fire Marshal, with PHMSA, and other applicable agencies if restart is contemplated. Prior to restart, a restart plan would be required. Since the details of that plan have not been developed, we cannot say which agencies would be involved in the approval of that implementation plan. It is unknown whether Santa Barbara County would have input since the decision to restart hasn't been made. But if it were made, that would be the process. As stated by Mr. Carlin, PPC is committed to evaluating the line and thoroughly reviewing both restart and replacement projects. That is a fair process to move forward, given the length of time it's taken to go through the replacement project. So with that, I'm available for questions. Any of our teams available. We respectfully request the Planning Commission deny the appeals and grant the valve application. Thank you very much.
We have a question for you, Mr. Grieg, from
Okay.
Commissioner Bridley.
Thank you, Mr. Gregg. So when you say that there would be a restart plan, is that some official document that is another, I mean, under what legislation or
Sure.
what conditions that happen?
So it's part of the consent decree that was agreed upon by the agencies after the release. So in that consent decree, it's laid out all of the steps. One of the steps, should it be contemplated that the owner would choose to restart, is to prepare this restart plan. Once that's done, then the details of that process would be known. Whatever approvals would be needed would be sought after. But we don't know that. We've not prepared that plan. It's not on the table today.
Thank you.
Sure.
Actually, I had a follow-up
Okay.
there, Mr. Grieg. You recall the question I asked of staff about if there was a restart with the existing pipeline, and would it require environmental review? And the answer was no, it would not. Do you have any different answer to that question?
I appreciate the staff's comment, Mr. Chair and members of the commission, that because we don't know what would be in the restart that would be approved by the fire marshal, we can't definitively say that. That depending on what that restart plan says, there may be some approvals required. We get approvals from Santa Barbara County when we maintain the line. So it depends on what's in that restart plan that determines what approvals would be required.
And some of the variables in that restart plan might be whether you're going to build a 12-inch high-pressure line or maintain a 30-inch existing line.
It's really hard to speculate, but it's hard to speculate. But
Okay, well, I already asked staff that question.
That's right, yeah.
Okay.
Yeah.
Thank you, Mr. Grieg.
Great. Thank
Anything
you so
else?
much. Anybody?
No.
Great, thank you.
Okay. I think we can close the public hearing, at least. And let's see if staff has anything else they want to tell us from what you've heard today.
Mr. Chair, no, we don't at this time.
Great. And do any of my fellow commissioners have questions of staff?
Just
Commissioner
one-
Bradley, go ahead.
One quick one that was brought up in public comment, and I forgot to ask it when we had the preliminary, but so the AB 52 process, which I know happens when you get a new application, you know, even before you start CEQA, what happens with that when you're doing a addendum?
Commissioner Bradley, through the chair, AB 52 consultation is not required when preparing an addendum.
Straight away. Okay, thank you.
All right. Any other questions of staff? Mr. Martinez does.
Yes.
I'm getting a little bit confused here, and I'm hoping that you can clarify for me, but, so in the report, there was mention of eminent domain, yet I hear the applicant mention that, hey, we already have the easements. So I'm wondering, why is eminent domain even being mentioned at this point?
Commissioner Martinez, through the chair. The proposal includes above-ground equipment associated with the MOV stations, which might not be a part of the original easement language. And so in order to make sure that the applicant is moving forward and complying with all easement requirements, they would need to reassess the previous easement language, update it if necessary, and then provide confirmation to planning staff.
Okay, so that basically the applicant has to go back, look at the deeds for easements, which some can be from the early 1900s and so forth, and,
Correct.
okay.
Any other questions of staff and commissioners? No. Well, then now's time for deliberations. And who would like to start that?
Well, Mr. Chair, I have a special request in that regard.
Certainly.
As all of us have up here and staff in addition, we've heard a tremendous amount of testimony today following significant submissions by all parties. And I'm left with lots of different thoughts that I'd prefer to present in an organized fashion. So I'd like to ask if we could have 10, 15 minutes max to recess and come back and start deliberations.
Oh, that's fine with me. I think it's a good idea. I would suspect that our deliberations will go faster if we take that time. So we'll recess for 10 minutes. All right. We're back in session for our afternoon hearing for the March 1, 2023 hearing of the County Planning Commission. We're still on item 1, and we're going to stay on it until we're done with it, and that'll be the day. So we're back in deliberations, and Commissioner Cooney suggested that we take 10 minutes to put our thoughts together, and we've done that. So now let's call on our commissioners. And whose light is on? Oh, okay. Well, who would like to go first then? I would often go first, in as much as this is at least partially in my district. But I think in my role as chair, I'd rather go last, and that's probably consistent with some of my thinking here as well. So I'd like to hear from other commissioners first, if you don't mind. Okay.
I'll take the dive into it first. Well, first I wanted to thank everybody who even participated in this matter today, and including those who spoke their minds on both sides, and that's what this process is about in my mind, so you know where I'm coming from. So I know you probably can see that I have my computer up here, and actually I felt like it was in front of a court of appeals, but everybody citing their legal laws and peppering it and being asked questions. But the way I looked at this is, okay, the focus on this matter is the valves, the installation of the valves. You look at AB 864, and just from me looking at it, it was this AB 864 was directly originated from the oil spill in 2015. And the headlines and all the other things that I read in regards to this was to lessen the risk of future oil spills and improve oil spill response. In that light, so I'm looking at this and saying, okay, this is our legislative body enacting this provision. And there's been arguments about CEQA. And the way that I've been hearing CEQA is really addressing the pipeline as a whole. In other words, the pipeline beyond the valves that are being addressed here today. And I understand that's a whole different animal. Now, and there's also been mentioned here is it's almost like as CEQA has been mentioned as a manner of stop the pipeline from restarting. And I don't believe that's what we're here about here today. We're here about installing the valves, and installing the valves as a safety mechanism in compliance with the response to any future oil spills and in compliance with AB 864. And so that took me back to, okay, CEQA 864, does it trigger it? And I looked at staff's reports, and I'm still coming to agreement with the staff is no, this is not a CEQA event, because the mention of the 8 miles situation and that this is being a piecemeal, I looked at that Santa Monica case, which was actually in one of the slides, and about parking and how what they did there is they took all these parking spaces and they put it together. Well, it's kind of the opposite here. No, not opposite, but synonymous in the sense of, okay, let's take these pieces of the valves and add them up to see whether it exceeds the 8 miles, because there they found that it was such a huge portion of the parking in proportion to what they were finding as for making those parkings for residents only 7 days a week. So I do listen to what people are saying in regards to making their quotations of cases and even try and look at them up here. I do agree with our chair that it would be nice if you're going to be making or citing cases, put them in there. Put them in a report, a memorandum. I, for one, will read them. So now we're saying, okay, maintaining the existing asset. That's some of the arguments that were made by the business Chamber of Commerce, I will say. And that kind of rhymes. I go, okay, well, 864 is talking about making existing assets safer. So I didn't really look into the easement situation, which, since that was the last question I asked of staff, because that really comes down to an interpretation of specific portions of person's land when they buy it. And I'm on the record of always saying, you know, if you buy a land and it's zoned in a specific area, or if it has these certain conditions, well, that's a burden that you buy it with. And I don't have the answer to that. I don't think it's necessary at this time of whether eminent domain or not comes into play. So I, for one, would say that I am in support of the staff's recommendations and would deny the appeal. appeals, I should say. That would be my analysis of the situation. Thank you.
Okay, thank you, Commissioner Martinez. Who would like to speak next? Commissioner Cooney.
I feel responsible to speak early as I asked for time to put some thoughts down, and I'm glad I did. It was such a good hearing in many respects, with all of the positions, all the possible positions being presented, and then sub-presented according to the positions of the parties, and I really appreciated that. I did think it was similar to a court hearing at various stages, because we had some of the most skilled attorneys, both generally and with regard to environmental matters, before us today, and that's not an every planning commission hearing occurrence. Yes, we could have had briefs laying out the cases, and I think we'd be right where we are now. We'd be deciding who's right, whose advice are we going to follow, and we're better off for the skill and the presentations of all attorneys. Mr. Marsh representing whom we've called variously the owner, the applicant, the successor, is obvious. I don't know him or his work at all, but I appreciate that he has a long career in environmental law. He has all the cases in hand, or can cite them, and he suggests that this is not a case for further environmental review. So I start with that premise, and I look at the very first finding that we have in our staff report, and it says that the proposed project is exempt from environmental review under the California Environmental Quality Act. I can't get by that first sentence, because I feel strongly that the appellants at various times presented reasons why we should have further environmental review before taking this part of the project and pulling it off. Some have said it's piecemeal. It seems to be that to me. The words "consider the entire project" came up several times in our written materials from all sides, and I feel we would be doing disservice to our constituency, our county, all who have appreciated the grandeur of our Gaviota coastline, to not deal further with the environmental issues that have been raised. The question remains to me how the environmental study should be aimed. We could all talk about that, but I think the right thing to do, and what I would recommend, is that we send the matter back to the staff to look at deliberations, assuming that there is not a majority in favor of denying the appeals. But I think it needs to be more than the addendum that staff dutifully prepared and discussed and did consider many of the environmental issues, but not the most crucial, which is this valve project is an end run to the cause of starting up another pipeline on the Gaviota coast. And I can't get by that. I can't support the very first finding we're asked to support. The public comment was uniformly in support of the appeals. There were two representatives from respective chambers of commerce, which I forgive in the sense that we've often turned to the chambers of commerce and the buildings and businesses of our county for information and support. In this case, I don't think either of the speakers was well-informed, but I don't disregard their comments, weighing against the majority of the public comments. I felt supported in the conclusion I have that we need more environmental review at a minimum. If I were forced to decide today, I would deny the project, uphold the appeals, and send the matter back to staff for findings for denial.
Okay. That leaves Commissioner Briley or Commissioner Freeney. Commissioner Freeney.
Thank you, Chair. Well, to me, I have reviewed everything. I think we did, one thing we can all agree on was the quality of the testimony today that we received. However, I see the quality of what staff has done and what the zoning administrator has done and how they came up with their findings, and I cannot argue their findings. There again, I understand the emotional charge of what's going on here, but I don't think this is the place to stop the pipeline. If that's what that's what the public wants. I can't support that at this time on this project. So I would move to deny the appeal and uphold the zoning administrator's findings.
Commissioner Briley.
Okay, so I have gone back and forth on this many times over the last week, and I definitely want to have a call out to staff because this was a very complicated case, you know, between history of the site and history of the operators and, you know, the ownership and everything. I thought you did a really good job of explaining it in the staff report. 5 days ago, I would have said, I'm going to fight for the right of entitlement. And I really, more than a lot of people would realize, I really think that we should respect people who have an entitlement because they fought long and hard to get it. I said that to the environmental affairs folks when I met with them. And then since that time, I read more and more, and today's hearing really influenced what I am now going to say, which is I don't think this is supportable as a case because so many things have changed since the original EIR was done, since the original findings were made. There are things like AB 52. There are things like changes to the Clean Air Act. There are things like the greenhouse gas things that have become tantamount in the last 5 years, all of which are changed conditions that I think warrant either subsequent environmental review or some further consideration. I love the fact that staff, and this is how I would have approached it too. This is just the valve replacement. That's what it looks like. However, because there's no other discretionary step before they turn the switch on, this is the precursor to turning it on. And I understand why staff has to segregate those two things. But given all of the risks that have already been taken and experienced, and given the confusion of who is it who's going to actually operate this, and that in particular, I want to thank Mr. Capello in particular, that really mattered to me a lot in our cannabis cases. I said, who are you? Who are you, LLC, that is going to do this 200-acre cannabis thing that everybody in the room is against, and I'm supposed to trust you because you say trust us? That, you know, sorry, you guys, that actually concerns me too, because I think it is a little bit of a change of hands, and I'm sure there's a great business explanation for it, but that also made me a little bit uncomfortable. So I am inclined to uphold the appeals and not support the case on this one.
Okay. Who's that leave? It leaves me. You know, I took a continuing legal education course on bias in January, which I'm required to do. And I learned a new phrase for me, affinity bias, and it was kind of interesting. It's not about whom I biased against, whom I biased for. And you know, I've been watching these environmental issues in oil since the late 1960s when I was a high school kid. And I have a lot of affinity bias for people in the community that have been concerned about this, including Mr. Capello. And on the other hand, I have a lot of affinity bias for the oil patch. I mean, I like going on site visits, to oil projects. One of the best site visits I ever had, the best I ever had, was when I went spent a day at the South Belridge field that was run by Arrow, which was Exxon's subsidiary at the time. Tremendous project. I like the morale of the employees, and I like dealing with oil company people. So those are my affinity biases. I have a concern I've expressed before about restart. And the concern I have is it's very directed. No one else ever talks about it, but I talk about it all the time. So maybe you all think I'm right, or maybe you think I'm a crackpot. But our GHGs in this county, prior to rupture, came in a very surprising percentage from the steam generating plant at Los Flores. And when that stopped, those GHGs went away. And if we restart, they're going to come back. And so unlike just about every one of the other 58 counties where GHGs slowly are going down, they would go up tremendously here. And I want to see that reviewed. I don't know what the ultimate end game will be there, but I want to see it discussed. I'd also like to see things discussed from the oil company's point of view. Here we have the 4th largest economy in the world here in this state, and we have environmental regulations that mandate certain mixes of gasoline. So if we don't have statewide or domestic oil production in this state, we do have security risks if there are interferences with oil otherwise. So we should be having a dialogue about those issues and the issues brought up by the UCSB students, that this is a life or death thing to them, and to the issues about, are we consulting indigenous communities adequately? Are we taking care of wildlife? And as I've said, taking care of environmental concerns with air. But you know, we can't have that kind of mediation or discussion here. We have to make decisions. This has been presented more or less as a legal argument. I understand what Commissioner Martinez talked about. It sort of felt like an appellate court hearing. If I was at an appellate court hearing, I'd have briefs from both sides with all the cases. Here I'm getting citations to cases. Even if I was writing them down, I couldn't write them down fast enough, and they're not in front of me. I'm mindful of a comment that my best friend Michael Benedict said to me, because he had served as a planning commissioner from the 4th District long ago. He said, well, John, you know, you're on this commission now, but you're not there as a lawyer. You're not there to lawyer for the commission. The county council is. And you need to have a different perspective. But if somebody makes all these legal arguments, I want to see the citations and so forth. But I'm also mindful of what Ms. Richardson repeatedly says when we say, what's our authority? And you say, it's in the full discretion of the Planning Commission, something like that, right? Do I have the line correct? I think so. And again, if I'm going to make a decision today, I think I would come down on the side that's been described by Commissioner Cooney and Commissioner Bridley, that I think this is maybe not a strategy of Exxon's, but it would be consistent with a strategy that would say, let's get around these environmental review issues by presenting this in a manner where we say, as staff has said, if you go to restart the old pipeline, big surprise to a lot of people, then there won't be any environmental review, and that concerns me gravely. So that's my thoughts. Would any of you like to make a motion that's consistent with how you see the commission is heading in this manner? Commissioner Cooney, you want to make a motion?
Right after
Oh, I'm
we hear
sorry.
from council.
Commissioners, I was just going to
Now
potentially.
now that I put words in your mouth, you'll like use your own, right?
Sure, I was just going to potentially frame the motion. There's been a lot of discussion, but what it sounds like is a majority of the commission is leaning towards a determination essentially that section 15162 has been triggered based on information presented today and in advance of today in the record, that there's substantial changes in a proposed project, substantial changes in the circumstances or new info of substantial importance that necessitates preparation of a subsequent environmental document, either a negative declaration or an environmental impact report, depending on the analysis conducted. That would today just be direction to staff to prepare that document and return. That wouldn't be any action to approve or deny the appeals or the project today. And then, just so everyone's aware, in the past, this type of direction to prepare a different environmental document has been treated as an appealable action to the board. So with that, if any commissioner would like to make a motion, but it would be direction to staff to prepare a particular document if you'd like to include any details of concern, but I think we've heard those. And then staff would renotice and return whenever it's prepared and ready.
Well, thank you for your direction. I was amazed at how quickly you can give us this great advice. Mr. Cooney.
Thank you, Mr. Chair and fellow commissioners. This is one of many very educational, appreciated hearings. We had the benefit of significant public input, which we sometimes don't get, and a wonderful staff report to start with. In the end, I disagree with the conclusions of staff, but not the methodology or not the effort. Some of our best staff were here today. Particularly good job by Ms. Knoll. She's appeared at our last two hearings in such a positive way that I hope she has the opportunity to come back soon. But in this case, I will move that the inability to make the findings required for approval of the project and to deny the appeals is the basis for my opposite conclusion that the Planning Commission at this point refer the matter back to staff for further environmental review, and at some time in the future they come back to us so we can consider the project with the environmental information needed.
Do I hear a second?
I'll second that, and maybe there's some discussion on the motion, because I'm a little bit confused maybe from what County Council directed. So a second, just to get it going.
Okay, then all right. Do you want to make those comments right now?
Yeah, could I, so it's an appeal. We wouldn't actually ask staff to return with findings for denial. We would just continue it until, because then what is it that the appellant has the opportunity to appeal to the board at this point?
So if the commissioners and the chair, so if the Planning Commission's action today is to direct preparation of a negative declaration or an EIR, the applicant could appeal just that CEQA decision to the board. This happened on a few projects. And then when the board heard the project, they wouldn't be considering the substance of the project, just whether the CEQA, the addendum is adequate, or if additional environmental review is required. If the commission believes there are basis to deny the project without conducting additional environmental review, then that's a different motion or action, and that would be to return if there's other findings that you would not be able to make even with additional CEQA review.
Okay, thank you. I'm just thinking.
So Commissioners Cooney and Bridley, what motion did you think you were making, and what did you think you were seconding in the light of that dichotomy that's been presented to us by our county council? Commissioner Cooney.
Thank you. No, I thought about it. I've mentioned that I'd prefer to deny it, but that is deny the project, uphold the appeals, and let the appellate process proceed beyond us. But I think we're close to having enough environmental information so that staff can make a decision as to what additional factors are involved, reconsider with consultation with county council the necessity of an environmental impact report, an amended environmental impact report, or negative declaration. But it's bound to, regardless of the form, it's bound to further inform us, and we'd be better prepared, I think, to consider the project in that light.
Penny, for your thoughts.
Well, my concerns weren't just with the CEQA. It had to do with the awkward ownership. It had to do with, I guess, conditions of new law and change conditions. That can all be, categorized into CEQA. I just thought it might be easier to have, just to uphold the appeals and deny the case and let them take it forward to the Board of Supervisors, because to return it to us for CEQA review, it wouldn't address the concurrent, replacement line status and the ownership status. That's not a CEQA matter. So I'm just thinking out loud here, and I'm kind of struggling. And I want to defer to Mr. Cooney because he definitely has more experience than I do, but I'm a little bit divided here. To deny or to continue for further CEQA?
Ms. Richardson, you seem ready to say something.
Commission, I thought maybe I would just set out the options. So today you have the information in front of you to deny the appeals and approve the project. If you wanted to approve the appeals and deny the project, that would at the very least require continuance for revised findings and documents to support that action. Or if you would like additional CEQA conducted, that's direction to staff, that would be done, and then the project returned to the commission at that time, and then you would consider the revised CEQA and whether to approve or deny the project at that time.
I'm going to confuse things even further. I'm not sure it matters to me, because I know that, given the kind of motion that we're likely to hear and decide, that and then given the length of time there will be until the matter is heard again, I'm going to keep thinking about this and thinking about this and thinking about exactly what's the right way to do it. And staff might come back with findings that meet what Commissioner Cooney has asked, and I might say that's just fine. Or I might say, no, I want to tweak them. I want to tweak them this way and that. And I'm going to use that time, it'll just happen with me anyway, to think about it and think about it some more. So we're not making a final decision today, I don't think. I think what we're doing is saying, please come back with some findings, and just like we do in every other case of that nature, we'll see if they work for us, or we might ask for something somewhat different. Does that help, Commissioner Cooney or Commissioner Bridley or anybody in the room?
So,
Oh, yes.
Mr. Chair and members of the commission, so I think what I'm hearing is there's a question as to whether or not additional environmental review will give the commission more information that would potentially change the direction of the commission. And so you have to ask yourself that question. If you think that there's more valuable information that will come from that process, then that's one direction you can take. If you do not think that's going to change your perspective and that there are other issues aside from the CEQA analysis that are problematic for you, then that leads you to the other option, which is to take action on the appeal and let it play out at the board level.
So I'm not dead sure. I mean, I believe there ought to be more CEQA review if we embark upon a path that takes us to a restart. And I don't want to be foreclosed from that kind of review, but there may be other things as well. It's a complicated case. And so I want the time to think about it, and I think I get that from a motion like this and having the time to think about it some more and seeing staff's best shot at some findings. Sorry, I can't be more precise.
Mr. Chair,
Yes, Commissioner Cooney?
we're in discussion on the motion, getting help from our director and our counsel. And it reminds me of other cases we've had where we weren't absolutely certain we were prepared to deny, but we couldn't approve based on the environmental record. I can't cite which ones, but we did get subsequent environmental review and went on either to deny or grant. It's appealable according to council, so a choice of the proponents here for the project would be to go to the Board of Supervisors right now to challenge the decision for more environmental review. That's not, I don't have a problem with that. I think environmental review is appropriate, and while I would be prepared to deny the project altogether today, I think the wiser course is to get all the environmental information we can get in a reasonable amount of time from staff, from consultants, from whomever, and then take another look at this ourselves rather than see it go to the board.
Commissioner Martinez, your
Yes.
light is lit. So
yes.
enlighten us.
Yes, it is. I made it clear that I'm really not in support of the motion that's being proposed, but just for an issue of clarification, though, the term project is being used here, and we're saying, oh, go back and do a CEQA or environmental review of what, is my question. Because the discussions we've even had today is not just about the valve, it's about the pipeline, the restarting. So where does the environmental review stop or even start? I think that needs to be, if somebody's going to say, let's send this back to staff, I think that full direction would have to be done, because otherwise, if it's just of the valve, and we have this meeting again, then the same argument's going to be made and said, wait a minute, this is about the whole project. Even though you did the environmental review, which has been requested today, we want you to do more. That's my concern.
Commissioner Cooney, do you have a rejoinder to that might clarify or not?
Yes, I in terms of environmental review, the environmental documents that we're dealing with are in large part very old, and just putting the year in there, 1983, as some said, 1985, those are old documents, and they're used not in a casual way here. The environmental review that was done with the addendum added to this nearly 40-year-old document is all we have. And I really think the circumstances that have to be notified, paid attention to, and reviewed have to do with our experience with that pipeline over a period of time. And I'm not going to change my view on that. I would hate to send this matter forward in any way relying on the decision of the Board of Supervisors back in the 80s that this project, this pipeline project, contemplated an oil spill, and they said it was more important to go forward by finding overriding conditions. And so given that we really are dealing with history here, I think we need a fresh look at that environmental review to either supplement or replace the old environmental impact report.
Did anyone from our staff table want to make a comment, or shall we go ahead with something?
Mr. Chair and Commissioners, if the motion, if Commissioner Cooney wants to make a motion on directing further CEQA review, we would ask for a short break because we need to confer on that to respond to Commissioner Martinez's question. So we could provide some guidance in regards to if that is the direction. If the direction is to continue it for denial, then we can just provide a date for when we could do that. Or the direction could be, I got on the mic, now I'm excited. The direction could be to, or the motion could be to come back with findings for denial, as well as add a direction to staff to come back with what additional CEQA would be or what that scope was to respond to Commissioner Martinez. That's like a option 3A to what Ms. Richardson talked about.
That's kind of where my mind's going to be anyway, to tell you the truth. That's what I just said, but because I'm not sure exactly. I want to see these alternative findings. But nevertheless, Commissioner Cooney.
Just to ask the question, to be on the same wavelength with Mr. Wilson, which is always a little scary to me, are you suggesting that we send the matter back to staff for some kind of additional environmental review? We don't know what it is right now, but let's come up with some language that does that. And at the same time, prepare the commission with the environmental review in hand for denial of the project, as opposed to, at that point in the future, sending it back for findings for denial.
It would be scary to be on the same wavelength. I think you're option 3B. So so what I was suggesting is, at this point in time, staff would need to confer on what, to Commissioner Martinez's comment is, what would be the scope of additional CEQA review? We're not ready to respond to that at this moment. We need to counsel or talk to each other on that. What I'm suggesting is, to buy us all some time, to Commissioner Park's comment, make a motion to direct staff to come back with findings for denial. And then the other part of that motion is to come back with an outline of what future additional CEQA could be as far as what that project would be. So then that way, when we come back, the commission could say, we have findings for approval, we have findings for denial, and we would actually know what future CEQA, additional CEQA would look like. Because at this moment, we don't have all those three pieces. And the other part is, does the commission even have an idea of what additional CEQA would look like? And so I think that's what's missing today, is we don't have those other options available to us or information. So that's my recommendation, is to do that. Continue it, we'll come back with findings for denial, and then also direct staff to come back with additional information as far as what would be the scope of additional CEQA. Or you can ask staff to look into that and bring that back.
So I see both Commissioners Bridley and Commissioner Cooney nodding their heads as opposed to shaking their heads, I think. And do you need a break to discuss this further among staff? Or if they agree with what you just said, is that something we can do, be done? Now you got to confer to see if you need to confer, right? No.
Mr. Chair, if you could just give us 5 minutes, that would be great.
We're going to take a 5-minute break. That'll probably last 10, but that's all right. We're making progress. Again, in our afternoon session of the March 1, 2023 County Planning Commission hearing. And staff has been discussing how best to handle a motion. And what are your current thoughts? Secretary Wilson?
Chair Parker, Commissioners, after conferring, I may be pulling back on my original option. Sorry. Commissioner Cooney. We think, based on the conversation amongst the commission and the discussion, our recommendation is to continue the item to April 5th and direct staff to come back with options on what additional CEQA may include or look like. That will give the commission time to consider the options, and then on April 5th, we can decide what direction we want to go. And then those options will be back on the table. As far as approve it, continue it for denial, but then you'd have options on what additional CEQA would look like on April 5th.
Just for clarification, I thought you first said that the options would only concern CEQA review. And then it made me think, but what if Commissioners Cooney and Bridley say, no, I really want to deny it? Does somebody then, at this hearing that's going to occur, let's say in a month, say, oh, we don't have those findings for denial, and now we need to continue it again, which I think would be pretty irritating to the applicant and probably everybody else. Am I making any sense?
Chair Park, that is exactly correct. We would ask you to continue again on April 5th. And the reason for that is it allows us to keep the continuity in the hearings, and so we're not arguing with ourselves. And so we would ask that we keep the existing findings in place, we come back with what additional CEQA would look like, and then if we still have a desire to deny it, or if you want to direct additional CEQA, we can do that. But if you do want to have findings for denial on April 5th, it would be a continuance, as you mentioned, Chair Park.
Okay, then I think Commissioners Cooney and Bridley, I'm addressing you because one of you is making the motion, one is making the second. You have sort of a stark contrast here. Either you want direction for findings for denial, or you want direction for findings requiring additional CEQA review. And would you tell us what your thoughts are in that regard? We'll be starting with you, Commissioner Cooney. It's your motion.
Let me ask a question of council. It may not arise, but the continuance that you're suggesting would not create a right to appeal our decision at that time. So the parties would have to wait with us to see what we decide at the next hearing.
Commissioner Cooney, that's correct. And part of the reason for the continuance is that if the commission does ultimately direct additional CEQA review, we want to make sure what staff takes and to go analyze is what you're looking for, not come back however many months later with something that is not what you were hoping for.
Well, the temptation I have is to move for denial today and let the matter move on. But I just feel so much work has been done by staff already in terms of environmental review. I'm hoping what we've heard today and our own opinions expressed today will give a little more leadership to staff in terms of what we'd like to see. But we could all disagree on the 5th and at that time consider denial. So, anything else to add before I make the motion? Mr. Wilson?
Chair Park and Commissioner Cooney, staff is, Hurley's scribbled notes, and based on, I guess, some scheduling issues, they are asking for April 26th. And we just want to confer that the applicant and appellants could be available as well on April 26th. There are some scheduling issues on the 5th and the 12th, I believe.
Okay. Let me ask, Commissioner Bridley, did you want to make any comments at this stage? Okay.
You don't know right now whether people are available on the 26th or we should use the 26th?
April 26th is good for staff, and I believe it's good for the applicants. We should confer with the appellants as well.
Okay, why don't you do that?
take another 5-minute break?
No, you don't need another 5-minute break. We'll make our saves available.
Okay.
Okay, okay, good. Ready for a motion?
I am.
Okay. My motion is that we refer the case back to staff and request that they confer and advise at the next meeting on this matter, which is scheduled for the 26th of April. We would take it up again.
I'll second that motion.
All right. And are there any comments on that motion? Any deliberation on that motion? All right.
Is there a time for that? 9 a.m.?
Well, the hearing will start at 9 a.m. Do we have other things on the agenda? I know you told us about that, and I forgot.
Chair Park and Commissioners, we could make their item the first on that date. We have 3 items on that date already, but we'll make this the first item as it's a continued item.
So, Mr. Capello, it'd probably be about between 9:15 and 9:45.
That'd be appreciated.
Yeah. All right, and staff has no further comments, so let's do this as a roll call vote.
Commissioner Cooney,
Aye.
Commissioner Bridley,
Aye.
Commissioner Farini,
No?
Commissioner Martinez,
No.
Chair Park.
Aye.
Motion passes 3-2.
Do we have any other business before the commission today?
Chair Park, that concludes our business for today.
Have you had enough, or shall we call it a day? The meeting's adjourned.